Having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. My name is Justice Vicki Henry. I'm your panel chief today. This is the May 7th, 2024 sitting of the Appeals Court. My pronouns are she, her. You're welcome to share yours or not as you see fit. As I hope you all know, each side has 15 minutes, and we, for better or for worse, do not allow rebuttal here in the Appeals Court. I assure you we have read your materials and are very familiar, so I'd encourage you to jump to the heart of the matter. I'm delighted today to be joined by Justice Grant on my right and Justice D'Angelo on my left. And with that, I will call the first case, 2023-P-738 Commonwealth versus Julio PEREZ-SANCHEZ.
Good morning. May it please the Court, Catherine Sullivan-Ledwidge on behalf of the defendant Julio PEREZ-SANCHEZ. The hearsay evidence underlying the new criminal charges against the defendant did not meet the Hartfield factors. Therefore, the Commonwealth's evidence was not substantially reliable and should not have been admitted or considered as a basis for a probation violation and revocation of the defendant's probation. Because this was documentary evidence, this court reviews that evidence de novo. The defendant's estranged wife's statements should have been excluded at the hearing. Although they met some of the Hartfield factors, they did not meet some significant factors. First, she was not a disinterested witness. She had a motive to fabricate abuse at the time of her report. She had just learned that day that the defendant had been cheating on her for a couple of months with another woman. And this was just before going to visit him on October 14th. And she texted him a few hours before she went to tell him how deeply hurt she was, how she felt betrayed and humiliated. She was also disgusted with the fact that he was being charged with child molestation charges. She was pregnant at the time, and she didn't want him anywhere near the baby. And she wanted a divorce, and she felt that he wasn't being cooperative in her divorce efforts. And I would cite to the Delaney case, Commonwealth versus Delaney, 36 Mass Appeals Court at 932 Note 4, where this court previously has held that, it rejected hearsay from an ex-wife, noting that the ex-wife was, quote unquote, no friend of the defendant. She also told different stories to different people about the October 14th incident. To her mother, before she visited, at approximately 5:10 p.m., she told her that she was leaving her phone in the car, and that if her mom didn't hear from her in 2 hours, to call the police, and she gave the address of where she was. After her visit, which was a text at 6:29 p.m., which I know was not 3 hours later, as the wife had said to police and in her grand jury testimony. But at 6:29, she texts her mother again and says, "I'm okay. He wasn't an a-hole." Her mother
Counsel,
said,
can I
Sure.
jump ahead to something else?
Sure.
The motion judge seemed to take a great offense to your client staying in Gloucester.
Yes.
And his affidavit admits that he stayed in Gloucester.
Mm-hmm.
Why isn't that alone enough for a violation?
Well, it would be enough for a violation, but not enough for this court to conclude that a revocation would have happened if this court...
The judge specifically, in his findings, when it came time for the revocation, specifically said about the Gloucester incident that he specifically, I think the words he used were, violated a specific court order. So why isn't that enough for us to find that the judge was sentencing partly, if not all, on that violation alone?
Well, I don't think it's for this court to speculate what he would do if, and I cite to Commonwealth versus Arroyo, if this court finds, after reviewing the hearsay underlying the underlying indictments regarding his wife and her 15-year-old daughter, if this court finds that that was not substantially reliable under Hartfield, then it would need to remand it back for disposition for whether it would be a revocation or reprobation or the disposition of the years that he gave. He gave him a hefty sentence of 3 to 5 years. And he did put in his findings and everything, it did impact him that, you know, these charges. And certainly he was very upset. And it comes across clearly how upset he was about the violation of Gloucester. So I don't doubt that he would have found a violation, but whether the disposition would have been the same, I mean, may or may not have revoked, but whether he would have imposed the same sentence is questionable. And under Arroyo, it says this court cannot speculate to that and it must remand.
You don't think we can infer that based on the fact that he specifically says if it had been just the driving offenses, I can't remember, operating without a registration or something, if it had been that, I wouldn't have revoked. You don't think we can infer that since he didn't reference the Gloucester as if that had just been the one, I wouldn't have revoked? We can't infer that.
No, and I would cite to Commonwealth versus Arroyo, 451 Mass at 1011. It's a 2008 case, and it says it is not for the appellate court to speculate what action the judge would have taken had he not committed the error. The appeals court should vacate the order revoking probation and remand for the judge to consider the appropriate disposition. I think that was the issue in Arroyo, that the appeals court felt confident enough that he would have revoked and left the same, and the SJC said no, it needs to be remanded.
I understand your argument that the wife's statements in the police report were not substantially reliable. Could Judge Drexler conclude that the police officer's statement in the police report that they saw red marks on the victim's neck and bruises on her right shoulder, that those were substantially reliable?
Well, I would point out that he could credit the testimony that they saw, red marks and bruises, but what does that truly corroborate except that they had sex like they normally did throughout their entire relationship? I mean, she described the sex that they had, and her daughter, her 15-year-old daughter, confirmed that she had seen marks on her mother and had asked her what they were, including bruises, and her mother told her it was from having sex. So I mean, it would corroborate that there was sex maybe, but not that it was non-consensual if we look at it in terms of, it's not unusual given the circumstances here and the long, you know, the sexual relationship that they had. So I don't think that alone corroborates or adds all that much to her statements. And then her 15-year-old daughter's statements, they were untimely. It was several months to almost a year before she disclosed this. She also...
So are you asking us to say that a sexual assault victim who delays telling anybody about the sexual assault is less credible?
No. What I'm saying is that in order for hearsay to be admissible at a probation revocation hearing, where it's exclusively hearsay to be the basis of a finding of a violation, it must meet Hartfield factors. And I'm saying that these are part of the Hartfield factors, and that, you know, the evidence in the report is recorded close in time to the event in question. And so that's just one factor that I'm bringing out to say that it's not substantially reliable. Also, she was not disinterested. She was quite clear that she hated the defendant. You know, she didn't like what she saw. And also, the context of the interview, I would say that she was prompted by the prosecutor during her interview. She was there to discuss her mother's relationship with the defendant, and she never spontaneously admitted or mentioned the defendant ever touching her. It only came out after the prosecutor specifically questioned her if the defendant had ever put his hands on her. She then said he choked her, but she also said that she didn't report it before because this was how the defendant joked around. And then the mother, the detective asked the mom about it, and she said, "Oh yeah, I saw it, but I didn't report it because I thought it was him joking around, that he liked to pretend to joke around." And, you know, not that I would have, you know, as a mom and everything, but I do know that men sometimes engage in horseplay, which isn't funny, you know, especially with women, immaturity and all that. And also, when it came to the mom, she told her friend around the time, but if you look at, and this is the problem with hearsay, every time it gets, you know, noted down and then repeated by the police, it changes a bit. And when you look at Detective J.E.F.R.'s repeating what her friend said, she said, Detective J.E.F.R. says, "Yes, I spoke with the friend, and she told me she'd been over the house with the 15-year-old daughter, and this daughter had told her, she thought it was a few days after the incident occurred, she had told her that at the time that Julio, you know, I think she used the word, was joking around and put his hands around her neck and choked her." So I'm just saying in the context of all that, I would say that it's not substantially reliable enough to have admitted and considered those hearsay statements. And then I think I have...
Did it matter that, as I understand it, by the time Judge Drexler was hearing this probation revocation hearing, the defendant had already been indicted by a grand jury for the sexual assault crimes, so that grand jury had found probable cause that they occurred?
Well, I don't think this, right, but I would say that this is not the same, I still think that no matter what, he had to look at the evidence before him, and it was hearsay, and it was, you have to go through the Hartfield factors. And
What if it had been the grand jury testimony? Would that be different? That's still hearsay, right?
it's still hearsay, and it's not subject to confrontation, so it's not substantially reliable.
Aren't there cases that say that a judge can consider grand jury testimony at a probation surrender?
If it's substantially reliable, and so he has to go through the Hartfield factors. No matter what, you have to consider the Hartfield factors and make a determination.
So are you saying, though, that the judge did not go through the Hartfield factors?
I believe the judge did go through the Hartfield factors, but I also believe that he was so incensed by the Gloucester incident, and that he had been president in Gloucester, that I think it may have shaded his opinions on other things, and that's why I believe it's documentary evidence. This court is in just as good a position to review that as he was, and under appellate review, with documentary evidence, there's no deferential standard for that. So, with all that, I will rest on my brief.
I take it that the criminal charges based on the alleged violations of probation are still pending?
Correct. I believe July. Okay. Thank you very much.
Good morning. May it please the court, Kristen Jing for the Commonwealth. The judge here did not abuse his discretion in finding the defendant in violation of his probation conditions and revoking his probation. Specifically, the record amply supports the substantial reliability of, I'm going to call her the wife, just to protect her anonymity, and the daughter's statements to law enforcement as to the defendant's assault on them. Factors supporting the veracity of the wife's statements to police include that her account was internally consistent, included specific factual details about the assault, and was reported to police within 48 hours. Her account remained consistent when she applied for a restraining order the next day, and the materials were entered into evidence, and when she testified before the grand jury under oath 6 weeks later. Police also observed visible injuries on her body during the police interview, which was consistent with her account. A third party, Keith Watson, also corroborated her account, confirming that she was at the apartment on the date and time when she claimed the assault had taken place, and even disclosed the details of the assault to him a few days later.
But I think she would argue, or has really argued, that that this woman was good at setting him up, right? That she waited for this opportunity when she was with him, and then made sure other people knew she was with him. But then we have the text messages to the mother, basically. I'm okay, he wasn't an asshole.
Sure, and there are also other text messages confirming her account. And I cite the King case in my brief, talking about how it's well known that victims, especially of sexual assault, it's not unusual for them to make a delayed disclosure, given the nature of the crimes at issue here.
So, but I agree with you, but that's exactly, so where we're on a documentary record, and there's stuff going both ways.
Yes.
And the judge is not looking at the person testifying, then how does one conclude one way or the other that there was, that the incident was enough to support a probation revocation?
Well, I would argue that the texts are just a piece of the puzzle here. We have also her video recorded statements to the police, so the judge and this court is in the same position and can actually...
Did the judge see the video recorded
Yes.
statements? Okay.
Yes, and this court should have them as well. So this court can actually see this witness give that initial statement to the police and assess her demeanor and assess the internal consistency of her accounts, the details that she provided at the time.
So do you agree with opposing counsel that our review of the documentary evidence is de novo?
Yes. Okay. Yes. Other than, there were police witnesses that the judge made credibility determinations, but I think here, because there were no percipient witnesses to this crime that testified, yes, it is documentary evidence.
You would agree that KS's statements, the repeated ones, none of them would fall within any of the exception to the hearsay rule, correct?
Yes. Yes, that is correct.
So do you think when the courts, our court and the SJC, have used corroborated, do they mean that if the alleged victim gives 10 statements over a course of time, that self-corroborates, or do you think there's supposed to be independent corroboration when they use that word?
I think it's all pieces of the puzzle, because we're talking about a preponderance standard here in a probation revocation hearing, so it's a little bit different than a criminal trial. But I think both of those would be corroboration, both that, if the victim provided statements a bunch of times and they were all consistent, that is corroboration. And also, in this case, for example, the visible injuries that the police observed, that is corroboration. Corroboration is the neighbor confirmed that she was there when she claimed the assault took place. So all those things form the puzzle that creates substantial...
But what about if, as often happens with sexual assault victims, the statement becomes more detailed over time?
Yes.
Or certain details come out more to a different audience? That's corroborative too?
It could, again, it's a preponderance, and it's up to the court to decide based on all of the factors here. There are a number of factors here other than just her statements, but sure, that could happen, and the defendant could argue that, that shows that, maybe it wasn't, she's not telling the truth. But I don't think necessarily...
Sounds like it's, I guess, to follow up Justice Grant's question, it sounds like it could be either or. So if they're inconsistent, it could still be corroborative that it happened, but it could also be something that the fact finder could look at to decide whether it's reliable or not.
Well, I don't think adding additional details is necessarily inconsistent if more details come out down the line. I don't think that's necessarily...
It's inconsistent with the first statement, isn't it? If someone adds something, it means it's inconsistent with the first statement by addition, just like it could be by omission. It's inconsistent with one another.
I think the defendant could make that argument. I think an inconsistent statement is if the victim claimed that a completely different thing happened or retracts her statement. I think that's a clear inconsistency, and I think every case is so different, so you really have to look to the facts of the specific case. But yeah, I think even if more details come out later in a different account, I don't think that's necessarily inconsistent, and I think you have to look at the entire case to decide whether it's substantially reliable. But I don't believe that is the case that we have in front of us today. As to the veracity of the daughter's statements, again, we have her account that is internally consistent, factually detailed, and based on her own personal knowledge. It was corroborated by a first complaint witness, her friend, who she told shortly after it occurred, her mother, somewhat corroborative account saying she saw something happen. And it was also, I would argue, consistent with the other statements she had made regarding the defendant, that he made her uncomfortable, that she saw bruises on her mother, that she actually had told her friend, the first complaint witness, about other instances where he had pretended to strangle her. I would argue that that's actually consistent with her account.
What do we do with the fact that there's all of these horrible allegations, but Judge Drexler seems the most focused on the violation of stay out of Gloucester?
I don't know that I would argue that he was most focused, because he did talk about and I'm just pulling up my notes on his findings here. He did talk about the terrible facts of this case, and I would argue he wasn't talking about the Gloucester order there. And you know, when the judge is standing before a probationer and is deciding whether to revoke and whether to sentence, there's a number of things that he has to look at, because he's actually sentencing on the original crime. So he's looking at whether probation is the appropriate disposition, looking at this particular person going forward, not necessarily on the facts of the alleged violations before him. So he did have to look at the history of this probationer's criminal history and this probationer's ability to follow conditions of probation.
Do we know which judge imposed the stay out of Gloucester and why?
I believe it was Judge Drexler, because he referenced on the record, I specifically told you, even if you're sitting at a bar in Gloucester, then you're in violation of this order. So I believe it was Drexler. It was this particular judge, the same judge.
He's certainly the one who took the GPS off the defendant and then made the specific order about Gloucester, and that's when he said, even if you go to a bathroom or a restaurant.
Right.
So I guess as a follow-up to Justice Grant, do you agree with opposing counsel that if we find that the new offenses, we can't violate on that because there's unreliable hearsay, that this has to go back to Judge Drexler for resentencing?
I think I have to agree with her, unfortunately, given the state of the law. I have the case and I don't have the site. I was actually on a case called Jamie King, and it was kind of similar facts where, unfortunately, even though there was a lot of talk on the record from the judge about how he was uncomfortable with this probationer's ability to comply, if there was an error in finding a violation, I think it has to be remanded. I think very likely it would be the same result, but I don't think that there's enough on the record that he would have imposed this particular sentence.
So I guess, so your view of the case law is that if an appellate court reverses on any ground on a probation surrender, it has to go back for resentencing unless the judge makes it crystal clear on the record?
Not on any ground, but if the reasons for violating probation were erroneous, but I guess here, there were other reasons for violating, unless it was clear that he would have revoked and imposed this particular sentence on the Gloucester, which I don't think he went that far, that he would have given this sentence.
His findings on page 119 of the record, he talks about 2 prior violations of probation. As aggravating factors, he specifically says, violated this court order after removal of GPS order in open court and acknowledged by defendant who went and remained in Gloucester. You don't think that's enough? I mean, he's puts it in writing that this is one of the reasons why I'm revoking. You don't think that's enough?
I completely agree. It's enough to probably find that he would have revoked, but to affirm this sentence, this was a pretty heavy sentence, as my sister acknowledged. So again, this is kind of against, but in fairness to the court, I do think the case law supports that it has to be remanded for resentencing.
I see we have an open motion, I believe, from you to transmit the body cam video.
I believe it was from my sister, and just for this court's convenience, I did mail a
Yes.
copy.
Did what?
I mailed a copy of the actual disc. I made a copy in the clerk's office just
Okay.
for ease of this court. So I don't think that that's necessary, but I'll leave it up to my sister. And if there are no further questions, I'm happy to rest on my brief. Thank you.
Thank you very much. Our second case today is 2023-P-1460, Commonwealth versus Jose Encarnacion. And we'll hear first from Attorney McKenna.
May it please the court, James McKenna from Mr. Encarnacion. Good morning. Let's get right to the heart of the problem with what happened in Superior Court. As a preliminary matter, the Commonwealth is right. The records of CJIS are business records for these purposes. As Justice Lowy and Justice Georges say in their concurrence in Gardado, they may also qualify as official records, but they are business records. The problem was they weren't what was brought to court. The problem was they brought a query, which was testimonial to court.
And I looked briefly for that in the record. Could you refer us to where, was that admitted, the printout, was that admitted as an exhibit?
It was not admitted, Your Honor.
Okay.
It's not part of the record. And if it had been brought to court by the person who ran that query, we wouldn't have this argument today. We wouldn't be here today on this point, certainly. There would be, as indicated by Judge Lowy and Judge Georges, the person who actually ran the query can bring that record, and there's no issue with confrontation, there's no issue with hearsay. That didn't happen. The deputy commissioner brought that record. The record was not admitted, and what we got instead was hearsay from the deputy commissioner about what that testimonial evidence was. So on this essential point, the point at which the trial was fought, on that point, the Commonwealth relied upon testimonial hearsay. The business records were back in the computer. The query, the affidavit was brought, and Your Honor, it didn't become part of the record. It could have become part of the record, and our case would be, well, our argument wouldn't exist if it was part of the record, if it had been brought by the person who ran the query. As indicated by Judge Lowy, it's hearsay, as happened here, when you have someone testify to the truth of the matter asserted in that query.
Was there testimony as to how complicated it is to run such a query?
Yes, yes, Your Honor, yes.
And is it hard, or do you just put in the person's name, their date of birth, then maybe an address?
That's essentially it. But
I can't hear.
Your Honor, that's essentially it. Essentially, it could be, there was cross-examination of the deputy commissioner as to other aspects of how that could work relative to other agencies to which there could have been applications. And but Your Honor is absolutely right. If it's typed in correctly, if all the information is entered correctly, it's pretty simple. Just, please, Your
So
Honor.
what do you say to Judge Lowy's footnote 8? This is not to say, however, that the testifying witness must necessarily be the same person who conducted the original search of the firearms licensing records that led to the charge against the defendant. Are you saying that we should hold that that's wrong and it's not enough for the deputy commissioner of CJIS to testify?
Judge Lowe and Judge George may have been thinking of a scenario where it's possible it wouldn't be hearsay. Here it was hearsay, because the statement as to what the query said came into evidence for its full probative value. My trial counsel was trying to set an indoor record, seemingly, for objections. There were objections to everything. In terms of an appellate record, this was wonderful to get. And in terms of the objections as to hearsay, it was perfect. So
Is Justice Lowy saying that you need the person who did the search, or is he saying that sometimes these records, the person who puts the stuff into the computer, not who just does the query, that's what's hearsay, is the person who puts the stuff into the computer?
he spoke about computer-generated records as
Right.
as indicated.
So are you agreeing that this is computer-generated records, that you don't have to have the person who put the things into the database?
Not the one who put the things into the database, the one who ran the query has to be there. Judge Lowy speaks about the person who, I think he used the term actually is the adverb he uses, actually ran the query should be in court, not the deputy commissioner. In terms of corroboration and reliability, this deputy commissioner didn't know who ran the query.
What if Judge Saab had said, okay, second call, Deputy Commissioner, you go out in the hall and use your computer and rerun the record yourself. And it doesn't matter that the defendant didn't get pretrial discovery of what you're about to run. I'm going to let you do that, and you can testify to that. Would that be okay?
Yes, Your Honor. There was a discussion at one point during the trial as to someone doing exactly that. It didn't happen. Instead, they relied upon a hearsay. So Your Honor is absolutely right. The deputy commissioner who was familiar with the system could have done exactly that and come back and said, I ran the query and pursuant to my capacity in relative to CJIS, that could have worked. There is a limitation concerning the Royal case and the Randall case, where a trooper contacted the registry and was told by the registry information which came into trial, and this court reversed on both Randall and Royal, saying that you can't just call the registry, get information as to status, and then introduce that for a substantive value. So there is that limitation. But had the query been run by someone who did so in the hall and came back into the courtroom, we wouldn't have this argument today. There's a second argument we presented, as the court knows, relative to the difference between a demand and a request. A demand being something that implicates involuntariness by its nature, whereas a request indicates that there should be a voluntary response. You can turn down a request, not a demand. And here, the lieutenant was very clear that he was making a demand. He stopped himself in his testimony. I asked, strike that, please. I demanded the production of the material. And
What do we do with the language of Chapter 140, Section 29C that says, any person who not being in his own house shall, on demand of a police officer, exhibit his license to carry firearms?
at least in this circumstance, that demand would be in violation of due process, in that it would require an involuntary response. The statute is very clear on that.
Well, would it? I mean, I think somebody would argue that what should have happened is that he should have said, I demanded his license, and he didn't produce it. And rather than put him saying, I don't have it, the officer would just say, the response would be, I demanded it, and then the Commonwealth would say, and did he produce it? And the answer would be no. Right? And is there anything improper about that?
No, Your Honor.
I'm
sorry.
I need you to talk a lot. I'm really having trouble hearing you.
For some reason, my voice isn't working terribly well today.
Okay.
Your Honor is absolutely right. If that had happened, there'd be no problem at all. If there was a testimony by the lieutenant saying, I demanded the production of the license and nothing was produced, that would be probative.
So it's what he said that was the violation?
Yes, Your Honor.
But that would make it a Miranda violation, wouldn't it?
It would be not Miranda, it could be Miranda in theory, but Haskell has excluded that, so we didn't argue Miranda at all.
Right.
We've talked only about voluntariness. The response...
So if he doesn't produce it, it's not involuntary, but if he says, I don't have one, it is voluntary?
The statement, I don't have one, is involuntary. Yes, Your Honor, because it's in response to a government demand. It's a submission to the show of authority by the officer. He's in handcuffs, and he's not being asked, do you have a license? The demand is made of someone by the government who's in handcuffs to produce something, and this is what a reasonable person would do in response. And this statement then implicated involuntariness. And from that perspective, there should have been a motion saying, you can't bring in involuntary admissions, as was this one.
Are you familiar with the case law that talks about that even once a person is charged and indicted with a crime, they can be forced to produce their tax records?
I am vaguely familiar with that, Your Honor.
Seems very similar to this because, as Justice Grant just said, there's a statute that specifically requires somebody who has a license to produce it. So why is this any different? They're asking him forcing him to produce something. Why isn't it any different than somebody who's already been charged being forced to produce tax records?
Your Honor, I think maybe the best answer to that is the point made a moment ago by Justice Henry. If there had been a demand like that and something's produced or there's indications as to what happened, apart from a statement, there's no argument. We have no quarrel with that. What happened here was a demand is made and there was an involuntary response. And that's the problem.
So are you asking us to say, police, even though you have this statute, don't demand the license to carry, say please, or make it clear that the person can refuse? Or are you asking us to say, police can demand under the statute, but if a defendant refuses verbally, prosecutors should not offer that refusal? Which are you asking us to do?
Asking you to say that if the demand is made, any statement made involuntarily in response shouldn't be allowed in. That's all we're saying. That if you respond to a government demand by doing something which is essentially involuntary, that goes against due process.
What if the defendant said, here's my license to carry? Does that come in?
It could, if it was voluntary, if he's in handcuffs and the demand is made to produce, and I think that would come in, but it wouldn't seem as though that would be involuntary. It could be, I guess, but if it were involuntary, it shouldn't come in.
What if it turns out it's in a false name or it's someone else's license to carry? Does that come in?
Then that's where it wouldn't come in.
So it only comes in if it's exculpatory?
It would only come in if it's voluntary. And it would seem as though, in all likelihood, if it were going to be exculpatory, it would be voluntary. Because if it was not going to be exculpatory, it wouldn't seem likely that it would be something done voluntarily.
What about when police pull somebody over and say, give me your driver's license? Because there's also a statute, I don't know what it is, but there is a statute that requires somebody upon request to produce a driver's license.
And
is this any different?
If the response to that is, I don't have a driver's license, it would be the same involuntariness. You're absolutely right. It would be the same. If there's a request made, may I have your license? Something like would be described in Murphy. This court in Murphy put it very, very well, that a request does not implicate involuntariness, but a demand does. And Rosenthal did the same type thing in terms of bless you, Your Honor, the submission to a show of authority is not voluntary.
So if the police officer pulls somebody over, he's got his full uniform out, his partner goes on the other side, and he says, give me your driver's license, that's different than if he says, may I please have your driver's license?
If something is said in response, yes. If
You don't think that's a show of authority? There's a police officer on both sides with police uniforms on. Because he says, please, that's not a show of authority versus give it to me?
Ron makes a good point in that regard. If there is something which renders that statement involuntary, it shouldn't be admitted. because involuntary statements shouldn't be brought in to convict. That's the essence of our argument. And because of that, there should have been a motion to suppress. There wasn't. What we had was a trial in which the trial counsel did a superb job of fighting the testimonial hearsay, all kinds of objections, great all the way through, and then left the door completely open to the involuntary admission coming in. And as the prosecutor said in closing, if you don't find that this testimonial, well, didn't say testimonial hearsay, if you don't believe the CJIS evidence, essentially, there's also the involuntary admission. Didn't use the term involuntary admission, but referenced the involuntary admission. And from that perspective, the defense couldn't work because they left that door open. And that's the essence of our ineffective assistance argument.
If we find that the CJIS information was properly admitted, would that make your argument regarding the involuntariness harmless error?
The question then would be, is there an assurance as to what the jury did, which they relied upon? The same thing would go the other way. If, in fact, we prevail on the CJIS evidence and the government had asked to convict on this basis, there can't be a fair assurance that they didn't. And vice versa. And unless the court has any further questions, thank you very much.
We'll hear from the Commonwealth.
Thank you. Good morning. May it please the court, Cynthia Payne for the Commonwealth. The Commonwealth is asking this court to affirm the judgments of conviction and the trial judge's denial of the defendant's motion for new trial. I'm going to go in the order that my brother had in his brief. Here, the trial judge properly, who is also the motion judge, properly denied the defendant's motion for new trial because trial counsel was not ineffective. Here, the defendant had to prove that his motion to suppress would be successful. And as the motion judge found, that motion to suppress would not have been viable. Here, the motion judge found that not only did trial counsel not have a deficient performance, but there was no prejudice. Moreover, the Commonwealth would note that this motion would not have succeeded because there was no affidavit that was produced saying that the defendant felt that he was compelled to comply.
Well, what do we do with the officers, I can't remember his officer or trooper testimony, where he's striking his own testimony and that he requested it and that he then changed it to he demanded it?
I mean, I think Haskell says that. Haskell was reversed because the police officer asked if the motorist had a license. Here, it's very clear in the statute that you must demand, and I think that's really the basis of Haskell. Haskell would have been reversed. The allowance of the motion to suppress, I suggest, would have been reversed if, in fact, the police officer had demanded as opposed to inquired. I would point out that—
I'm confused. What is it that you think we want the officer to do? That they should demand and not say, please, may I have your license?
That's exactly what the statute says. That's exactly what Haskell indicates, I would suggest to this court. Your Honor, I would point out that, I would respectfully suggest that my brother
So once it's demanded, why is it a voluntary statement from the defendant who's standing there handcuffed?
I would suggest that the standard of whether or not a reasonable person would comply, which is the standard in search and seizure cases, Murphy and Rosenthal, is different from a compelled to a person's will being overborne. Your Honor, I understand what you're asking. I would point out that really, though, the key of this particular issue is the ineffective assistance of counsel, that certainly this did not rise to the level of ineffective assistance of counsel. And even if, I don't know the answer as to, all I know is what the SJC has said in Haskell, that the officer must demand, and the statute indicates you must demand.
Well, here's something about the statute that has been in my mind. The statute doesn't really apply to the defendant because he doesn't have a license. If you have a license, it must be produced upon demand. So if you do actually have a license, the police have a right to ask pursuant to the statute. If you don't have a license, the statute doesn't apply to you, does it? Crazy as it sounds, but the statute only talks about someone who has a valid license must produce it upon demand.
And I would suggest that the police officer did exactly what the statute indicated. He demanded his license. He did not ask him. He did not ask him to respond. He demanded a physical response. Give me your license to carry. Defendant chose to answer. He chose to respond, I don't have one. Again, I would go back to the fact that this particular issue, that it was not ineffective, and the motion judge, who was the trial judge, found that this motion would absolutely, if trial counsel had filed a motion to suppress on this basis, it absolutely would not have gone anywhere. Moving on.
Well, so why not just ask the officer, and what did you do? And then the officer says, I demanded the license, and then you say, and did he produce the license? And the officer then just says no, and then we just avoid this.
That's certainly a great suggestion, Your Honor. That's not, unfortunately, what we have here, but I certainly think that may be a good way to go forward. In regards to the second issue, the deputy commissioner's testimony was proper, where she testified that she'd been with CJIS for 21 years. She was very familiar with how firearm records were created, accessed, and maintained.
Right, but so she's got with her presumably a piece of paper that someone's printed out that says he doesn't have a license, right?
Correct.
And is that piece of paper, as opposed to all the other records, a business record?
I would say no, that was not a business record. And that was not ever, as my brother told the court, that was not entered into evidence. Here,
What's the basis for her testimony that the defendant did not have a license?
Because he had no license. It wasn't a question that he had once had a license. This was a computer-generated record, where there was the computer followed an algorithm, and people, other than inputting data of the defendant's date of birth and name, there was nothing that people had to do. So there was a big difference, and I think this case is different from Royal. Royal was a computer-stored records, which in a case of a suspended license where someone actually has to go in and enter the fact that the license was suspended. Here, this was totally computer-generated. Case law indicates that when it's computer-generated, this is not hearsay. I would suggest that because it's a very easy query, it's essentially like adding numbers on a calculator, and if, in fact, during the break, as Justice Grant indicated, it would have been, perhaps would have been fine. Probably should have had the deputy commissioner run the information prior to trial. But in any event, because this was a computer-generated record, because this particular person who testified was very familiar with how records.
Isn't it irrelevant whether she's familiar with it or not? It's that she, quote, reviewed a firearm license query by someone else, and it showed no record. Someone else did it, and they found that there was no record. That's hearsay, isn't it?
I would suggest that, again, because this was computer-generated, that's the Commonwealth's argument that, yes, she's looking at a query, but it's a query where the defendant's name, date of birth was inputted. It has the date the query was run, and I believe there's...
Why isn't the fact that it says no record? That's what it says on the computer-generated form.
That's correct.
Why isn't, quote, no record hearsay? It's an offer being admitted for its truth, i.e. that the defendant had, quote, no record.
I understand what the Commonwealth's argument, again, goes back to this is a computer-generated record, notwithstanding the fact that she did not run this particular query. She was very familiar. She testified that she was aware when queries were run, very familiar with DeCegis, having been there in that position for quite some time.
Again, is it relevant at all that she knows how it works? I mean, under your very thoughtful analysis in your brief, this record could be given to Police Officer Joe Smith, and he says, I've reviewed this record, and it says the defendant has no record.
Well, I think Justice Lowy made it very clear in his concurrence in that footnote that the individual who testifies has to be very familiar. You can't just have a police officer who doesn't really know how the system works. She testified and gave quite a bit of background as to how the Firearm Records Bureau runs, how Merck's, the information behind Merck's. So if this was, I would suggest this was the correct person based on all her knowledge and her position in DeCegis. In any event, the Commonwealth would suggest that this, the fact that the defendant did not have a license to carry was cumulative of the statement that when
Before we get to that, and there's definitely some circularity to that.
True.
If I'm understanding you correctly, you're saying there'll have to be a different standard and a whole different process for somebody whose license is suspended as opposed to somebody who had no license.
That's correct, and I think that's the difference between computer generated and computer stored. Computer stored, where when someone's license is suspended, just like with a driver's license, somebody actually has to go in and input that information. That becomes the hearsay, and I believe that's what Royal states. Here, there's...
Yeah, but I guess I'm a little troubled, because then I'm trying to understand how you would ever prove someone had a suspended license, because how would you prove it then?
I know there's, well, suspended, I think you have to have a different person testify. I actually
You
didn't...
can't be saying you have to have the person who keyed it in testify.
No. I apologize. I was very concentrated on computer generated, so because this was not an incident...
I'm very concentrated on what's going to cause problems later, because we always have to think about the intended
Certainly.
and unintended consequences of our decisions, and it seems like it would be a nightmare if we suddenly had two different rules.
Certainly. I would go back to, this, of course, was under the rubric, well, of counsel not being effective, and this was the Commonwealth's second argument in that because this was cumulative, I would suggest that cumulative evidence is harmless, if this in fact was error, would be harmless error.
Wouldn't if a firearms license is suspended, you have to give that firearm person notice, right? When it gets suspended?
Yes.
So this would be like the Registry of Motor Vehicles sending out a notice. They create it, not in the anticipation of litigation, but they create it when somebody gets their license suspended, it goes to them, and then you do the certificate. It's exactly the same thing. Right?
Yes, and in fact, that would be the answer, where we would have the admission of a business record. We did not, in this case, we did not have a business record entered, so.
Because you're proving a negative. That's the problem with Guadardo, is you're proving a negative. The reason why there's no information in the computer-generated documents is because the defendant never had a license to input into the system.
That's correct. Unless.
So in theory, could the witness present to the trier of fact the millions and millions and millions of records in the system and then testify the defendant's name is not among them?
Well, I would suggest that would not be efficient.
No, I know, but
Well, if it's alphabetized, maybe you could just take a portion, but again, I think it's no record is because it's not inputted, which I agree. She testified that she had all this knowledge. The question is, I think for us, or is, do you need the person who actually ran the record that says no record? I'm not saying that's correct, but Justice Grant's suggestion of just go run the record, you do it, might have been more prudent.
Certainly.
But then the problem is discovery.
Yeah.
And defense not having an opportunity to call an expert, et cetera.
Yep.
Unless the court has any further questions, the Commonwealth would rest on its brief. Thank you.
Thank you. The case is submitted. We'll call our third case of the morning, and then after that case, we'll take our mid-morning break. 2023-P-1042 Commonwealth versus Matthew Vaillette. And we'll hear from counsel for the defendant first.
Good morning, Your Honors. May it please the Court, my name is Daniel DiMaria, and I represent Matthew Vaillette, the appellant. Your Honors, vulgar, profane, offensive, or abusive speech does not, without more, constitute disorderly conduct. That's from the SJC, the juvenile case. Matthew Vaillette may have been acting like a jerk on the evening of December 8th, but there's a big difference between acting like a jerk and actually being guilty of disorderly conduct. His conduct did not come anywhere close to what is necessary to constitute disorderly conduct.
Why isn't these, and I call him victim, I know it's not the victim, it's a community crime, but why isn't stepping towards the gentleman and stepping onto his property threatening behavior on the defendant's part, so it's disorderly?
For two reasons, Your Honor. Number one, at all times, the complainant testified they're at least 25 feet away. And secondly, when Mr. Vaillette set foot on his driveway, he was laughing and giggling, which is not threatening demeanor.
How far onto his property or his driveway does he have to go for it to become threatening? 15 feet, 10 feet? What line do we draw?
Your Honor, I believe the main criteria should be demeanor, laughing, giggling versus approaching menacingly.
No offense,
Well-
and I haven't watched the video that came in, we got it, I haven't watched it, but somebody can have mental issues and be laughing and seeming odd, but as they go towards a person, that can be threatening, can't it? So the fact that your client was laughing as he's stepping onto the property going towards the victim, we really can't go by demeanor alone, can we? Wouldn't it be what a reasonable person might perceive is happening?
Your Honor, I would still submit that laughing and giggling from a distance of 25 feet, I appreciate the question. You know, I think being face to face, would be completely different. But also, my client simply called the gentleman a racist 3 or 4 times, which I would argue, and the issue here, Your Honors, is the trial judge did say this is the very definition of tumultuous behavior, but if we look at the case law, this comes nowhere near it. There was no testimony whatsoever as to noise. I know the Commonwealth in its brief.
So let's go to that. You say there was no testimony that the defendant yelled, but where the defendant first spoke to Mr. Naciccioni from 50 to 60 feet away, why don't we infer that the defendant yelled from that distance? I mean, I could barely hear the last guy from here to the bench.
I mean, even taking the record in the light most favorable to the Commonwealth, 50 feet is not, that might be across a double-lane road. I believe it's generally accepted each lane of traffic is 12 feet. So I think I could speak from the back of the courtroom without a microphone almost 40, 50 feet, and you could hear me just fine without my having to yell. And I would submit the fact the Commonwealth repeatedly, at least 8 times in its brief, said he was yelling, he was yelling, he was yelling, suggests that they believed that without that was basically an integral part of the offense. Now, when we looked at all the case law, in almost every other case cited in my brief for the Commonwealths, there was some sort of hitting or bumping, In Richards and Blavakas, both involved punching or striking a police officer. In Chuth, there had been threats to hit. In Mulvey, the man had bumped the police. In Sinai, there had been an attempt to hit. These cases are a lot more serious. In my reply, I went through great pains to distinguish my case from the ones cited by the Commonwealth, and there's a night and day difference. And this all comes down to, as well, the First Amendment, that speech without more, the courts have repeatedly held, does not constitute disorderly conduct.
But that goes back to, you go.
What about the fact that, according to the testimony, your client yelled "fucking racist" 3 or 4 times? Assuming he didn't yell, assuming it was a conversational tone, that it was repeated and that it included an obscenity.
Well, the first thing that came to my mind, Your Honor, and during the body cam video, which is part of the record, my client states that Mr. Natticcioni had baited him. So the first thing that came to my mind is, what if he actually is a racist? If he is, then that's absolutely fair game. Assuming he was not a racist, the record's completely silent on the point. He said it 3 or 4 times. The testimony does not elaborate. You know, was it a long, drawn-out speech? Did he simply mutter it 3 or 4 times? We simply don't know from the record.
Well, but that's where, you know, we do look at inferences. So we have a guy who's out fixing his Frosty the Snowman ornament or, you know, holiday decoration. He does not know the defendant at all, and the defendant starts saying, or yelling, but let's just say saying, from a distance of 50 or 60 feet, that he's an effing racist. So why doesn't that allow for the, and then he moves towards him, and then he's told, don't come any closer, and then he comes closer and he steps on the guy's property. Why is that not enough to be tumultuous behavior?
So, Your Honor, one of the factors of tumultuous behavior is noise. Another one is attracting a crowd of onlookers. In almost every case cited in our briefs, a crowd was attracted. And I think that also goes...
But if he does it and there's not many people around, why does that mean the conduct is not criminal?
I would submit, I mean, it's a residential street. It's 7 or 7:30 at night, and on a cold December night, I would think that if he had yelled and it was more than just a passing remark, neighbors would have peered out, would have come out, seen what was happening. I mean, if the court were to find that calling someone a racist 3 or 4 times on this record was, you know, was disorderly conduct, that would be a massive expansion.
I don't think that's what the Commonwealth is arguing or we're suggesting. I think we're suggesting there's more to that, which is the witness tells him, move along. He doesn't move along. Instead, he approaches the witness. He is acting in an unconventional manner, and then he steps on the fellow's property. And clearly, Mr. Natticcioni is threatened because he says, if you keep coming, I'm going to sick my dog on you. That I think we can infer he felt threatened from that, can't we?
I would respectfully disagree. To me, and he never testified he felt threatened. His only testimony was that he felt aggravated. It seemed to me like Mr. Natticcioni was a, you know, tough guy who could stand his own.
It does seem he was a tough guy.
I don't think he felt threatened at all. I think, you know, from the defendant's demeanor, there's nothing. 25 feet's a distance. He had a dog that let out a lion's roar. I really don't think he felt threatened. I think he was confronted.
Well, he kind of said, if you come any closer, I'm going to sick my dog on you. That doesn't seem to be defensive posture on his part.
It seems to me that he was confronted with possibly a mentally ill individual, and that
who steps towards him twice and onto his property, right?
He stepped onto his driveway twice. You know, Your Honor, I could be on the sidewalk in front of your house, and I
agree. But the difference here is that he makes the comment, the person, the neighbor, responds, and he continues to come closer repeatedly. I guess I'm trying to distinguish in my mind the First Amendment here, which I agree is protected, from the acts that the defendant did that made it disorderly, according to the judge's version. And you're not finding anything threatening at all about the defendant's conduct.
Based on his demeanor, absolutely not. The fact the man had a dog with him, if anything, would have, in the man's eyes, lessened any perceived threat.
I mean, the cases that talk about First Amendment rights are if your client had made these comments and had just continued on down his way and said it to a bunch of people protected by First Amendment. Here, what I see the difference in some of the First Amendment cases is that the defendant did something else. He made a gesture, according to the cases, towards the neighbor. And you don't see that gesture as having any significance, legal significance.
Because of his demeanor, Your Honor, unfortunately, I won't capitulate just because he was laughing and giggling.
So does it change, and I'm unclear whether we have one act or two acts, but does it change where the defendant continues down the street? So let's assume for the moment you're right that the witness didn't feel threatened, but he's watching the guy continue to walk down the street, and then he sees him yelling effing racist at a home of an elderly couple that the witness says he knows is home. And now he definitely is feeling quite concerned, and that's, I think he testifies to that. So why would that then not be enough? And now we know he can hear him from 100 feet away.
And, Your Honor, I did read that in the Commonwealth's brief, but my reading of the transcript, we can't actually tell that he testified that anyone was home. I know it's in the Commonwealth's brief, but that was not my reading of the transcript. But even if they were home, they didn't come out. The officer never went and spoke to them. As far as I'm concerned, it would be a non-issue, even if they were home. At a minimum, we'd expect them to come out. They may not have even heard it as far as the record is concerned.
So the complainant testified that your client was only yelling, seemed to only be yelling at people. He was only screaming at people that had only the ornaments in their yard or their house. Are you arguing that your client's yelling had some sort of a political or religious component to it?
It's not part of the record, Your Honor. It does seem from Mr. Nataccioni that it's the Christmas ornament that made him refer to him as a effing racist. So,
Frosty the Snowman.
Yes, Your Honor. So there could be that component, but it's really not part of the record, and I don't think it makes any difference.
Would it make a difference if it was a creche instead of a Frosty the Snowman?
I don't think it would, Your Honor. I mean, if it was a swastika or, something glaringly racist, then it absolutely would. But I just don't think we come anywhere close to disorderly conduct on these facts, even with these neighbors who didn't testify. There's absolutely no mention of them other than Mr. Nataccioni's very brief testimony.
I hate to go down the rabbit hole, but why would it make a difference if it was a swastika and he said to the neighbor something racist? I mean, why does it make a difference? It's still protected by the First Amendment, isn't it?
Right, Your Honor, I'm saying it would be just so appropriate, for lack of a better word, to call someone with a swastika, a racist, that we absolutely would not be here and that would be completely legitimate speech.
So looking at the trial transcript on cross-examination, he basically says, that he knows the people in that corner house are an older couple, so it's one of those that's why I just made the phone call to be a decent citizen. Why can't we infer from that he's concerned for them, that the defendant's behavior, at least directed to other people, has not caused him to be fearful for them?
Even if he is fearful, it's still disorderly conduct requires tumultuous behavior, which the courts have said involves excessive noise, crowds, those types of things. So I think that just takes us outside of the statute. And, Your Honor, I think you've made my point for me in that I was arguing Mr. Natticcioni did not feel threatened, and the fact that he actually says he called because he heard Mr. Vallette made remarks towards the neighbor's house, that to me shows that's why he called, not because he felt any perceived threat.
So the Commonwealth says you just need to be in a public place, that's enough. Why are they wrong about that?
Your Honor, I agree that being in a public place is sufficient. It's, that's one of the elements, but that still does not get us to tumultuous conduct or anywhere else on the first element, in my respectful submission. And, Your Honors, if there are no further questions, I would rest on my brief.
Thank you very much.
Thank you.
We'll hear from the Commonwealth.
Good morning. May it please the Court, Donna Marie Heron, Assistant District Attorney representing the Commonwealth. Here, there was sufficient evidence to sustain the defendant's conviction for disorderly conduct where the defendant, while on a public street, approached a complete stranger who was in his yard, began yelling at him, continued to approach the stranger despite being told to leave the area. There was evidence that he was yelling. I suggest if the Court looks on page 14 of the cross-examination of the victim, it says, "And how far were you standing? 150, 100 feet? Okay, and what did he say?" He yelled the same thing. And that's why the thing I could think of was, I told the officer the same thing, and that I think he had some kind of issue because he was only screaming at people who had ornaments in their yard. That is direct evidence that he was screaming.
This seems like a good opportunity to ask a question here. We do view the evidence in the light most favorable to the Commonwealth, but I've always wondered when a witness says something equivocal like this, whether it's 100 or 150 feet. I mean, I think 100 is probably enough, but still, I'm just going to ask the question. So in the light most favorable to the Commonwealth, do we go with 100 or do we go with 150? Because it seems sort of wrong to make it more than what the witness said.
I think the key part I'm looking at that sentence is he was screaming at people. I don't think it matters the distance of where he was at, whether he could hear him.
Okay, he does actually use the word yell right there at line 20.
Yes, he does, and he uses the word screaming too, which I think is even more.
Yep, that's down on 24.
If the defendant in this case had made the comments from the distance, and let's assume we accept that he's yelling.
Yes.
But he keeps going down the street, looks at the neighbor says, stay away, keeps going down the street, and he yells at everybody that has these ornaments. But nobody comes out. Is that disorderly?
No. I think it's clear, and I asked the Court to look at the Cahill case, which I know is annoying and accosting, but they talk about disorderly conduct in there, and they say language itself is not enough. I'm sorry, what?
Which case did you want?
Commonwealth v. Cahill. I cited it in my brief. It's from this Court, 64 Mass App 911. It's a 2005 case, and it's annoying and accosting, but they talk about disorderly, and they say speech in itself is not enough. However, a comment or act coupled with an aggressive move towards the victim is, and that's exactly what we have here. We have a guy, the defendant yelling, the complaining witness telling him, I think he said, get the up, move along. He then steps closer to him, continues to yell. He says, if you don't leave, I'm going to sick my dog on you. That's when he starts laughing, and he moves a step closer again towards the complaining witness. And then that's when the dog left off the roarless bark, and that's when the defendant, I guess, takes off down the street. But again, then stops in another neighbor's house and says the same thing. I think in the light most favorable to the Commonwealth, that clearly meets the elements of disorderly conduct.
Right, so just because it can be helpful to sort of clear away things that are not relevant. So do you agree there was no evidence the defendant used physical force?
No,
You agree?
I agree with that.
And there's no evidence that the defendant actually used violence?
Nope, I think he's threatening behavior, which is in the statute, and tumultuous behavior, which is what Judge Noonan found in his order. When he said his verdict from the record, he's found that the defendant was tumultuous and used threatening behavior, and that's why he found him guilty of disorderly conduct. And I think Judge Noonan was 100% correct in his findings.
So I know the defendant his counsel mentioned there were 2 steps on the property. I was trying to figure that out from the transcript, which I've read. So where is the second? I know I'm very clear he steps on the guy's driveway, but where's the second step?
So I'm just quickly reading it, sorry, on page 10, he says he's 55, 60 feet away when he starts yelling at him. I told him in terms, just keep walking, leave me alone. He then Does he do something? Take a step forward? Yes, he did. How close would you say? He stepped a foot into my driveway. Okay. And when he proceeded to the driveway, what did you do next? I then proceeded, so he's already taken a step towards him. I proceeded to let him know if he takes one more step on my property, I release my dog. At that time, he kind of giggled. His second foot hit the driveway, and that's when the dog let out so he takes
Okay.
another step forward, as how I read that, and then the dog lets out the roar. And that's when he decided to beat feet as fast as he possibly could, is how the victim testified. So to me, that's 2 steps towards him. And again, this is at night. He doesn't know him. It's a complete stranger. I would say all the elements of disorderly conduct under the threatening and tumultuous behavior were met. It's clearly a public, because it's on a public way.
So briefly speaking, then, the tumultuous behavior from your point of view is the speech combined with the approach, combined with failing to heed the warning to go away, combined with the 2 steps?
Yes, Your Honor. And he tells them, and he clearly knows it's threatening, because he's saying, get away. I'm going to let my dog out if you don't leave, leave. So I think that meets the last that the defendant knew, or a reasonable person would know, that the complaining witness, who is a member of the public, so that element is met, is alarmed or annoyed or inconvenienced by this behavior. If there's no further questions, the Commonwealth will rest on its brief.
Thank you very much. The case is submitted. We'll take our mid-morning break, which is usually in the neighborhood of 15 minutes. I think on our last sitting, we came back a little earlier than people expected, so I don't want to catch anyone unawares. But I would say you can count on 15 minutes. This is a continuation of the May 7th, 2024 sitting of this panel of the Appeals Court. Our next case is 2023 P1125 AR versus J.E.F.R.
Good morning. May it please the court. My name is Francie Gazaniga. My co-counsel, Krista Ellis, is sitting at counsel's table. We represent the appellant and the plaintiff in the underlying abuse prevention order case, which was brought on behalf of a minor child who I will refer to as GC or as victim. There are three issues in this case. The probate and family court erred by applying the wrong legal standard and abusing its discretion in denying the extension of the abuse prevention order. 2, the probate family court abused its discretion by relying on collateral matters, including conditions in a criminal case. 3, the denial of this abuse prevention order went against the public policy of protecting victims of sexual assault and the fundamental right to be protected from the impact of violence. Thus, today we're asking that you put plaintiff in the position she would have been if the law was applied properly in the first instance by reversing the probate and family court's order denying the extension, directing the probate and family court to promptly issue an ex parte abuse prevention order against the defendant until June 28, 2024, which would have been the one-year extension date if it was extended. On that date, issuance of a new order would be dependent on the plaintiff continuing need for the order at the extension hearing, and we ask that extension hearing be heard in front of a different judge.
Can I ask about your remedy?
Sure.
How do we know that if the judge had appropriately acted, and this is a real hypothetical, the judge had appropriately acted, hadn't extended the restraining order, doesn't a judge have discretion about how long he or she extends the restraining order for?
For the most part, under the abuse prevention order guidelines, the default should be 1 year.
That's just a guideline, though, but the statute gives the judge discretion, correct?
The discretion is as with the desire of the, let me strike that. The extension default is for 1 year, and usually it's at the victim's request, and if they ask for 1 year, it's supposed to be for 1 year, unless there's some reason the judge finds that less than a year is appropriate, but normally the purpose of the abuse prevention order is victim focused, and the modern view is that the victim determines what is safe for the victim. And normally the default is 1 year, and it should be 1 year unless the victim asks for something less than that, Your Honor. So as far as our request, this is modeled off of the Calliope case that was recently decided. And I think this is very similar in a lot of ways to that case. And another request is that we ask, like the Calliope case, you issue a published decision in this matter, so it is binding precedent. These issues occur quite regularly despite your and the Supreme Judicial Court's clear guidance on abuse prevention orders and the burdens for extending them. Reiterating the standards in a published decision would signal to the public, and most importantly the courts, that the victim's safety is the sole focus of abuse prevention orders proceedings. And
what do we do with the judge's finding? The court does not find reasonable plaintiff's testimony that she is still in fear of defendant and so does not credit this testimony.
So, Your Honor, we believe that she applied the wrong legal standard in making that determination. In plaintiffs in GC's position who are applying for a restraining order and extensions under Section 1C for past sexual violence only need to show a continuing harm or continues to suffer damage from the sexual assault. Not that future abuse is imminent, not that there are violations of the abuse prevention order. If you also look at her findings, a lot of the findings go to why the order should have been extended in that case, including they go to the same school. The judge found the defendant was at plaintiff's lunch, even though he normally isn't supposed to be there. especially while the restraining order was active. They live in the same town, and most importantly, criminal charges were pending for the defendant with GC as the victim, and these charges were rape of a child and indecent A and B on a child under 14. Each of these instances meant that the parties were going to likely see each other, and the criminal case was likely to engender hostility. So again, going to the findings, the plaintiff GC testified to her continuing mental and physical suffering based on the sexual assault. The findings do not state that the court doubted GC's testimony in that. Most of her testimony was uncontested because the defendant didn't testify. The only matters that were really discussed even by defense counsel were the collateral criminal conditions, which I'll get to in a second. But in Supreme Judicial Court in Iammelli specifically states, if the plaintiff were suffering from attempted or actual physical abuse or involuntary sexual relations, there is no question that an extension should be granted. That was reiterated in a more recent, the Yana decision. So if a plaintiff is getting an extension based on Section 1C and seeks protection from the effects of past sexual abuse, she needs not allege a fear of imminent future sexual abuse. In this case, again, she was still suffering the damages from that. And
Can I ask you about that? There's still a requirement, and I believe you said it earlier, of ongoing harm or continuing harm, and I think you used the word damages. Is there any case law that defines what that means, or do we need to make a definition of what that means?
I don't believe there is anything that I can think of off the top of my head, but I think the testimony of this plaintiff, that she suffers from PTSD, anxiety, nausea, like looking at her body, and if someone touches her without consent, it really traumatizes her. And the fact that she has to continue to see this person in school, in the criminal case, it is, I would say, obvious harm. At the time of this hearing, it had been a year and I think 5 months since the incident happened. I think there's many cases that say the mere passage of time does not alleviate those burdens, and there's several cases from the Supreme Judicial Court and this court that specifically delineate sexual crimes as particularly harmful and having long-lasting impacts and various impacts that don't happen to victims in other crimes. So, and specifically in the matter of a motion to compel, they reiterated the public policy to assist victims of sexual crimes to recover from these injuries. So in this case, although the findings do state that, I would note that the findings were issued after our notice of appeal. And I would say, getting back to the judge relying on collateral conditions in a criminal case, that is, from the record, why she denied this order. So the findings issued afterwards, I think, have less controlling than the actual record before us. Again,
So you argue, I think it's a heading in your brief, that the findings do not state that the trial court doubted her credibility on her continuing mental and physical suffering due to the assault. I'm back to where Judge Grant was, which is, is that accurate in light of finding 30, that the court does not find reasonable her testimony, she's still in fear?
Your Honor, I would say that this finding does state that the testimony was still in fear. I would say that it's not credited because the judge made findings that it wasn't reasonable, but I think a victim who was sexually assaulted at 13, with it being such a short time afterwards and having to see the plaintiff in her regular course, I would find that an abuse of discretion in saying it's not reasonable, Your Honors. And more importantly, again, although the findings were...
To see the defendant, right? Just want the record to be clear. You said where she has to see, you said the plaintiff, I think you mean the defendant.
I'm sorry, yes, Your Honor. See the defendant in her regular course, including most importantly, the criminal case that was ongoing with fairly serious charges. And
But
going back.
counsel, that asks us to reverse a credibility determination. And that's why I asked you about ongoing harm. What if we credit the judge's finding regarding credibility, that she's no longer in fear? That's not an element of this extension of a restraining order, is it? It's ongoing harm. That's not the same as continued fear, is it?
Correct. I would say that many cases say it's ongoing harm. And
So let's say a sexual assault victim goes out and gets a black belt in karate and a gun license and testifies, I'm not afraid of him anymore, but then testifies, I have PTSD, and I can't sleep, and I shake, and I have other symptoms. Would that be enough?
I think in that case, Your Honor, if a client came to me and said, I'm not in fear anymore, I would have a lot of questions about if she's saying that as a protective measure to not portray weakness versus whether she's actually has a continuing harm. And to be honest, in that situation, if she really believes she wasn't, and I say she because majority of victims are female, but it would be unlikely that client would be asking for an extension in that hypothetical specifically.
Right, but I think picking up on what Judge D'Angelo said, does the harm have to include fear? You might have a victim who denies they're in fear on the stand, but testifies to effects, to harmful effects, not including fear. And I guess my question is, would that be enough?
I think in that situation, and going with the modern view on what's protective of victims, and including looking at the Violence Against Women Act and emergency transfers in housing, although it's collateral matter, I think what is safe, it should be, especially in a victim-centered proceeding like abuse prevention, should be up to the victim. So in your hypothetical, if the victim said, I'm not in fear, but I'm still suffering all of these things, and I think this abuse prevention order would help me recover from those injuries, I think in that situation, the judge should extend the order, because fear would be reasonable, but I don't think that should be the standard, and maybe there should be some clarification on that from your court. But in this specific case, going back to the judges...
How about, I love following up my
Sure,
colleagues.
I've seen a pattern.
I'm not in fear of him because I'm not in fear of him, but I don't want to see him anymore. He makes me sick. Logical response to somebody who's been sexually assaulted, maybe. That's an ongoing harm, but it's not fear. The statute would allow, in your view, for an extension in that situation, right?
I think if the victim's asking for an extension and she's saying that this order would help her recover from those injuries, I think it would be appropriate for the judge to extend it in those situations. And again, going back to this case, it's clear from the record that this abuse prevention order was not extended because of the conditions. This is a direct quote.
Yeah, so, and I'm not in any way foreshadowing how this case is going to come out. We'll talk about that after argument, but I'm not sure you could have both types of relief you seek. In other words, with our published decisions, they go through a long review process that, given today's date, would not issue before June 28th if we did a published decision.
I think in the Calliope case, even though it was published, the order to the underlying court, which was district court in that case, the court did move pretty quickly in ordering that extension to happen. Okay. So that's what we would ask, and that's why we're modeling off of that case, because I think that was a strong signal to courts that, hey, if you're not doing the right thing and continue to do the wrong thing, we are going to make you do the right thing. I think that's important going forward for the protection of victims going forward. And I mean, to quote the judge in this case, it's a difficult case, folks, because of the youth of the parties involved, but there's a criminal case pending. He, the defendant in this case, is under conditions in the criminal case. I'm not extending the order. He's under conditions on a criminal case. And again, just like the Calliope case, this judge was more concerned about the collateral consequences to the defendant rather than protecting the victim, which is the focus and the only focus of an abuse prevention order proceeding. And it said, well, on your way to screwing up your life, so this is your chance, sir, to straighten out your life. And I think that's inappropriate. This court has said several times it's inappropriate to rely on those matters. And the reason for that is the public policy is to protect victims. Without victims being able to access this, it is an access to justice issue.
I have two questions before you run out of time. The judge found that the plaintiff credibly testified that the defendant appeared at her lunch period in the cafeteria, and he remained over 5 yards away. Is that a contact? Is that a violation of the order, not to contact?
I think normally they consider contact like talking to or sending a letter. He wasn't supposed to be at that lunch period. The school, when the order was in effect, was very careful about their schedules and avoiding that, but that day he was there. The school resource officer determined he was beyond the 5 yards, but...
My other question is, I understand that the judge found that the screenshot that the plaintiff took of the Instagram contact from in the defendant's name had not been authenticated. Could the judge still consider that as to the plaintiff's fear?
I think it should have been considered, and going back to the first ex parte hearing, there was a lot of communication about his friends contacting her and a lot of different things. They weren't specifically violations because it couldn't be proven that he directed it. But yes, these contacts and like the ongoing fear, having to go to court again was very traumatic.
Like in the olden days when a restraining order plaintiff might get hang-up calls on their phone, and they couldn't prove that they came from the defendant, but they could testify that that was part of what made them afraid.
I would say that's very similar, or like a strange car driving by and you can't exactly pinpoint it. I mean, normally people don't have these kind of things happen in a vacuum, and they're normally someone you know most of the time. It can't be a violation, but I think it should go to the ongoing fear and harm of a victim in these situations. And I think that's a logical leap that a judge should take in. So I know I'm over time, so unless there are other questions, I will rest on my brief.
Thank you very much.
Thank you.
We don't have an appearance from the appellee, and we don't have an appellee here, so the case is submitted.
Thank you, Your Honors.
The next case is 2023 P880, Department of Children and Families versus Mother and Others. Now, I understand we're going to have a time split on the parent side, and each parent will have 7.5 minutes. I also want to caution everybody that I've been doing this 8 years. Every time you use the actual names in the brief, somebody says the name. So I want you to prove me wrong. So we're going to stick with mother, father, child. I know there are 2 older children. We can call them child C and child, I can't remember, child J, but we do not need to use anybody's names today, okay? Definitely, please prove me wrong about saying the names. Really would like that.
Good afternoon. May it please the court, my name is Lynn Alderman Boyer. I represent the mother in this matter. And just straight away, Your Honors, I just want to say for sections 1 and 2 of my brief, my arguments, I'm going to rest on the brief. As you know, this is a case where we have another oral argument directly following, and it's related to this. So for those reasons, I'm going to defer to counsel for the co-custodians, which is what my first and second argument is about. So, Your Honor, I have 7.5 minutes, and I am going to argue for the arguments 3 through 5 in my brief, and those are based on the 60B motions that Mother had filed in the trial court. That was back in 2023. And just yesterday, Your Honors, I actually had filed a 16L letter for the Franklin case, and that is the case that I'm going to be discussing. for that 60B motion. So the 60B motion was heard, it was filed in January of 2023. It was heard in February 6th of 2023. There were 3 issues addressed there. It was placement of the child at issue in this case, and placement with the co-custodians, who had been the co-custodians for just under 2.5 years of this child. And then sibling visits. The child has 3 other siblings. One is aged out, but she had requested to, and that I'll call child W. She's the oldest child, doing quite well, goes to Northeastern pre-med program, and that's in the record. So she had requested that. And then there is child J and child C. They have a different father, say Father J. So they had requested sibling visits, the 3 siblings. And then the third...
You represent the mother.
Yes, I do.
So I'm confused about why you're arguing about what the siblings are requesting. Why does the mother still have standing to assert anything about sibling visitation?
So, Your Honor, she was coming in under 60B5. So the way that, so initially, the co-custodians did not have counsel. And so with their permission and mother's permission, I brought in 2 motions, one under 60B4 for the co-custodians, and then one under 60B5 for mother. So mother was not asking for a trial to relitigate unfitness. She was coming in and asking for the, so basically for the child was in his 5th placement. That placement was with the sister, the half-paternal sister in Texas that had disrupted.
We're very familiar with the facts.
Yes. So when that disrupted, Your Honor, she came in under the judgment being inequitable based on the disruption of the placement.
Do we have any transcripts of any hearings that happened since February of 2023?
We have, no. So February 6th of 2023 is when that was argued.
Right. And so we're just deciding whether or not the judge properly decided after trial to terminate the parents' rights. So my understanding is that you were arguing below that the aunt and the cousin had rights to counsel because they were custodians within the meaning of, I think it's section
119, section 29.
26.
Oh, no, 119, section 29.
29, right.
And under Manuel, Your Honor, too, like the reading of the 2 of them together.
What do you say to DCF's argument that the "or" in that statute means that either the parents or the custodians have the right to counsel?
I mean, Your Honor, a reading of the statute, I would argue that it's off point. It's more of a listing of, parent, guardian, custodian. And in the juvenile court, we have custodians, third-party custody is given quite routinely to parents, family members, or...
So is it your position that the aunt and the cousin had the right to counsel at the first 2 days of trial in early in the year before the removal happened in March?
That's correct, Your Honor.
They also have the right to counsel back in 2018 when the care and protection proceedings were first started? And they were a kinship placement, I think?
No, not at that point, Your Honor. It's when Section 24 kicks in and a 72 when there's an emergency removal what the argument would be is under 119, Section 29, in a reading of Manuel, that the custodian who was given direct custody by the court when there was an emergency removal, so they were given direct custody by the court, I think, in May of 2019.
You have the judge's order giving them direct custody in the
Yes,
record?
Your Honor. That's all part of the transcript. It is in there, yeah.
We have the transcript of that May 2019 hearing?
Yes. Yes, and it was conditional, it was a direct conditional custody. So part of the argument there, and I know my sister, when she comes up for the co-custodians, is going to be arguing this more in-depthly.
Well, where in the record, on direct examination by the dad's counsel of both the aunt and the cousin at trial,
Yep.
the lawyer said, I'm showing you a document. That's the conditional custody order, but it wasn't marked. Do we
Yes.
have that document?
No, Your Honor, I do not know what that is, and sometimes when you are given conditional custody, you get a piece of paper downstairs that actually just says you have conditional custody. It's something that they give you to present to a school.
The docket in May 2019 has the word form in all caps and square brackets.
I don't think I've ever seen, I know the condition, so in there's multiple hearings, Your Honor, that actually, I spent a lot of time actually going through all these hearings, and it appears that in the first hearing, there was a conditional custody order for the great-aunt and the great-cousin, but the great-cousin was not even present. He was not even there.
So, back to the issue about the or,
Yes.
don't we need to read that in conjunction with Section 24? And I'm going to read you a sentence and tell you if you think this sheds any light on what the or means in Section 29. If no parent can be found after reasonable search, a summons shall be issued to the child's legal guardian, if any, known to reside within the Commonwealth, and if none, to the person with whom such child last resided, if known. Then later in that same section, it talks about notice to appear shall be given to either parents, both parents, a guardian with care and custody, or another custodian. Isn't the statute setting it up so that you either have the parents, or you have a guardian if there is one, or you have a custodian if there is one?
And Your Honor, I agree that there can be, so the way that I read it, I agree that there could be, especially in juvenile court, any one of those three types of individuals could be appearing. Sometimes we have a guardian that got guardianship from the probate and family court, and they have custody. DCF comes in for a removal, and the next thing you know, you're in juvenile court, and you're a pre-existing guardian. At the 72-hour hearing, Section 24, you would never have a direct custody yet because the court does that at the 72-hour hearing. So you wouldn't come in as a custodian, so to speak. That happens when the parent presents another person as someone to take the child.
So is it your position that in addition to the aunt and the cousin having the right to counsel, they would have had the right to cross-examine all of the witnesses at this trial and to present their own permanency plans?
So, Your Honor, it would be my position that at the time of this trial, the co-custodians had custody for just under 2.5 years. Yes, I would say so I looked to Manuel too, that also talks about, it's a very similar situation where it is a custodian that is an aunt.
Are we bound by what the district court judge did in 1997 in Manuel?
No, Your Honor, you're not bound by that, but I do believe that it makes sense when you look at it from the situation where we had two custodians of very sizable length of time with this child.
So we've got two bio parents.
Yep.
And two temporary custodians. What if all four of them say different things should happen with the kid?
So, Your Honor, I think part of what my argument was in the brief is that the trial judge in this case rolled in the 72-hour with a termination trial that was already happening, which is what I refer to as tainting. It kind of tainted everything because the 72-hour hearing, I would have argued, should have been separate from the termination trial. And then we're just looking at the emergency removal from the custodians versus lumping in a termination trial with the parents. And one of the things that really sticks out when you kind of look at this trial is that we have the co-custodians that speak only Spanish. They didn't speak English at all. They were on Zoom because it was during COVID. It was the early stages of Zoom, and we all know how difficult that is. There was an interpreter.
But you didn't raise any issues about the problems with Zoom?
Yes, it's in my brief, yes. It's, I believe it's in argument 1 or 2, and there is an affidavit from the co-custodian from the 60B motion that I had discussing, so she's, 59, and she doesn't speak.
How do you distinguish adoption of Jacob?
I am not prepared to answer that question,
Okay.
Your Honor, I'm sorry.
Can you just plainly lay out the timeline of when the child's Texas placement was disrupted? In other words, what was the date of that, and how soon after did the mother file the Rule 60B motion?
Yes, Your Honor. So the disruption occurred so the timeline that I have is that the mother got word or a video of late November so some of this is outside of the record, so.
Don't say
so I'm
anything
not
outside
gonna
the
say-
record.
But what I will say is that in the affidavit that is attached to the 60B, we learned that the Texas placement disrupted around the end of November. It was confirmed by DCF later than that. So in about less than 2 months, I had the motion filed. So that was October of 2022. Did not find out till about mid-December of 2022, and the motion was filed January 27 of 2023. And the motion hearing, so it was less than 2 months. It was a 36-page motion. It was filled with a lot of facts.
Okay, so if we agree with you that the guardians or the custodians, that there should have been a 72-hour hearing,
Yes, Your Honor.
but there wasn't, so what relief can we offer other than saying in a future case there should have been a 72-hour hearing?
So, Your Honor, one of the cases that I added just recently, which just came to knowledge to me, is adoption of Franklin. And in that case, it has to do with 60B motions. And in adoption of Franklin, so there's 3 cases that I've kind of looked at. One was adoption of Theodore, one was adoption of Caesar, and the other was adoption of Franklin. In adoption of Caesar and Theodore, there had to be a substantial change in the parent in order for the court to, and they all had displacements, might I add, too. So there was displacement of the child in all 3. But adoption of Franklin didn't require a displacement. It just looked at, it didn't require a substantial change in the parent. The parent had a little bit of a change, but not a substantial change. They looked at the disruption of the child and the best interests of the child. And similar to this case, the child in this case, in the disruption, it was his 5th disruption, 6th placement when they came back, and then I don't know how many more after that. And what the court looked at and remanded back down is they looked at how the judge looked at the evidence of the case and weighed it, and they decided that the judge did not adequately consider all the facts in the case, and that's what I would say here. So
You said earlier that there wasn't a 72-hour hearing.
there was, but it was intertwined with so it was on May 19th and May 20th. The termination trial had already started. It was already started. So then on May 19th and May 20th, the custodians came in as witnesses only. Part of why that makes it difficult is that they don't have counsel. They don't speak English. They don't know what's going on. And then on top of it, it's a conflict of interest from mother and father who the co-custodians could be testifying against to act as their attorneys. Also, the judge did give a reprimandment about the co-custodians talking to counsel. I believe it was for the father.
It wasn't about talking to counsel, it was about lying and saying she didn't talk to counsel when she did.
I think, there was a lot of, Judge Henry, there was a lot of confusion for this client in terms of being on Zoom, not really being able to, it's in the affidavit, not really being able to understand, the translator was going really too fast for her a lot of times. And it was the beginning of using Zoom, so there was a lot of problems, even in the Even in the transcripts, they were going off Zoom. There was a lot of static. There was a lot going on there. And I think she was very, very confused. She was very confused about who was talking to her, who was supposed to be talking to her. A lot of these things could be avoided if you have counsel yourself and you're given counsel. And
All
I will
right,
say-
I know, I'm very mindful that you're over your time by more than your time.
Yes, Your Honor.
Is it fair to say the mother, father, aunt, and cousin were all aligned in agreeing that if the mother did not retain custody, then they all wanted the aunt and the cousin to be custodians?
So that is true. Mother also did have, want her mother, the maternal grandmother in California, to be considered as well. And I think the department was also looking at recruitment for adoption. That was part of the plan as well. Not mother's plan, obviously, but.
And you said there was a 72-hour hearing?
So, Your Honor, it was just kind of meshed into the.
What I'm
best-
really trying to get at is when was the 72-hour
So
hearing?
I guess the way that they treated it is on May 19th and May 20th. That's when the custodians testified on those 2 days.
Right.
But they didn't give a decision. It was rolled in. It was like they kind of rolled it in, but that's when they testified, May 19th and May 20th,
When was the child
2021.
When was the child removed prior to that?
The child was removed on March, they did an emergency removal that was allowed on March 15th of 2021. And then the hearing was kind of intertwined where they gave their testimony on May 19th and May 20th of 2021.
But it was March 15th that the judge said, okay, we'll schedule the 72-hour hearing. Actually, it was April 15th, when the dad then moved for temporary custody.
Yes, they moved, yes, Your Honor. Boston does it a little different. Some courts actually, you just get a 72-hour, I guess, in whatever court they were in, they had to request it. And Your Honor, just very quickly in closing, under adoption of Franklin, the court had ruled that.
Very familiar with adoption of Franklin.
Yes, I know.
I think we need to wrap it up.
Okay,
20
okay, Your Honor.
seconds.
Okay, thank you, Your Honors. I
Thank you.
appreciate it.
We'll hear from counsel for the father.
May it please the court. Good morning. My name is Andrew Hoffman. I represent the appellant father in this case. On his behalf, I'm asking that this court vacate the trial court's order terminating the father's parental rights based on the trial court's error in its choice of competing adoption plans, as the plan proposed by the parents to have the guardians to return the child to the prior guardians, the aunt, was the appropriate plan, and instead of DCF's proposed plan, which was to explore the possibility of adoption by either of two relatives or failing that, recruitment for adoption. I'm arguing that as a result of the error in the choice of competing plans, the termination of the father's parental rights was erroneous.
So, counsel, assuming that the aunt could meet the child's basic needs, let's just assume that, I know there's some issues about whether that's true, but even if that were true, but could be easily manipulated by the parents into letting the parents have unsupervised access to the child, would that be enough to not allow the aunt to continue as a custodian?
Well, certainly the trial court has broad discretion to make that decision. I don't think that if the trial court based its finding on that alone, I don't think I'd argue that that was erroneous. However, part of my argument here is that, my argument here is that there was ample evidence in the record that was just simply ignored, that had findings been made based on that evidence, would have undercut or undermined what Your Honor just stated, which is that the aunt was incapable of setting proper limits on the mother. If I may, I can explain what I'm talking about. So obviously the kind of, I won't say linchpin or turning point in this case was the March 2021 removal from the aunt. And a substantial portion of the judge's findings is devoted to this. The judge, as you said, found that she was unable to keep the child safe, unable to set limits, easily manipulated. Prior to March 2021, DCF had instructed the aunt that she could rely upon the mother's program to provide supervision during the visits. with the child, and that the great aunt did not need to be present for those visits. Further, DCF, keep in mind at this point, DCF did not have custody of the child at this point. They were not acting as an agent of the court, and they had no authority to set or modify the rules of the mother's visits with the child. However, it was clear from DCF's statements to the great aunt that DCF endorsed this supervisory structure despite the fact that it was in contravention of what the court had ordered in its temporary custody order, the conditions. Now, the DCF worker confirmed that the great aunt had informed her on February 24th, 2021, that the child had an overnight visit with the mother at her program and that he had adjusted back into her care well. DCF approved of this progression, despite the fact that one of the original conditions was no overnight visits. All of those things that I just said did not find their way into the findings of fact. That's my whole argument here, is that there was a lot of information in the evidentiary record that simply was, the phrasing I used in my brief that I'll use here again today is that these are errors not of commission but of omission. I'm not arguing that the judge's findings of fact that she did make were erroneous. I'm arguing that where she erred was the findings that she didn't make. So those items that I just mentioned, even though they're in the record, did not appear in the findings of fact. And there's no explanation. Those are not matters of credibility that the trial court judge has the discretion to determine credibility. It had nothing to do with credibility. Similarly, a third instance, or a third example of that is that the DCF caseworker provided the great aunt.
As far as the visits at the shelter, as I understand it, the judge found at finding of fact 192 that the team met with the aunt on January 29th of 2021 and told her that the mother's visits with the child were to take place at the shelter. And then later the mother told the aunt, deceiving her, that she had basically graduated from the shelter so that it was no longer necessary. And even though the aunt knew about her doctor appointment for 3 days, she didn't call DCF and ask for help about trying to find another caretaker. She just believed the mother when the mother said, don't worry about what DCF said in January, I can have the kid now.
Right, you're correct, Your Honor. The aunt relied on the mother's statements without any kind of corroboration, just basically trusted the mother. But the factual assertions that I'm referring to were DCF's statements to the aunt that were clearly different than what the court had ordered. And so the aunt was, I don't think there's any question, was reasonable in relying on what DCF had stated to her. That, if, for instance, I'll go back to the one where the great aunt had told her, this was in February 2021, that the child had had an overnight visit, and DCF, upon learning that, had no problem with that. Didn't.
But I thought the judge didn't credit that the DCF worker had said it was okay.
There was one instance where the DCF worker denied in her testimony having said that. There was, but like I said, the DCF had instructed the great aunt, again, this was in March, prior to March 2021, that she could rely upon the mother's program to provide the supervised visitation. The DCF worker did not deny that. My point is that the great aunt was reasonable in relying upon the DCF, and where DCF diverged from what the court had ordered, that tends to undercut this notion that the great aunt was simply.
Isn't the question whether the aunt was reasonable in relying on the mother?
No, I agree. I do not contest that it was not reasonable for the great aunt to rely on the mother's assertion that she had graduated from the program. But my argument is that there were instances, like I'm citing, that DCF had not taken any issue with the great aunt doing things that were not consistent with the court order. DCF gave it its blessing, and so my argument is that she relied reasonably on DCF, not on the mother. No, I agree with you. Her reliance on the mother saying, "Oh, I graduated the program, nothing to worry about," that's not. I'm not arguing that that's reasonable, but I do think that the court's omission, again, lack of a better word, omission, just without explanation, ignorance of, no explanation for why it just didn't cite some of these facts in the findings of fact, just no mention of them whatsoever. And again, we're not credibility decisions, just simply we're not there. The source of many of the factual assertions with DCF itself, I realize I'm running short on time. There's numerous instances, they're all cited in my brief, of DCF's testimony at the trial that countered the judge's findings, largely related to the great aunt doing a good job with the child, providing good care, the failure to or the absence of referrals for additional services. In other words, if the child's developmentally delayed, you would think that DCF would
Do you agree that none of the judge's findings that were written, there were none that were erroneous?
I did not argue that in my brief. I'm not arguing here that any of the findings that the judge did make were erroneous. What I'm arguing is that the ones that numerous instances, again outlined in my brief, the evidence is there in the record. There's no questions about credibility. The judge simply didn't touch them in her findings of fact, no explanation. And my argument is that the case I cited in my brief that I cite here is custody of Eleanor. The language is that with regard to judge's erroneous findings, that although there's evidence to support it, the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been committed. I would argue the same applies where the findings are not made, where there's evidence in the record that is ignored, is omitted, that there's a definite and firm conviction that a mistake has been committed. So I'm over time. I will, unless there's further questions, I'll stop there. Thank you.
Thank you. I understand as well on the appellee side, we're splitting time 7.5 minutes, and I'm mindful that we went over, so we'll see how you do with the 7.5 minutes, but if there's more questions, we might well run over.
May it please the court, Jeremy Bailish for the Department of Children and Families, and I do apologize. I've been having an issue with my contact. I'm not tearing up. I just had to take that out. We're here today to discuss the merits and validity of the court's decision terminating mother and father's parental rights. Mother and father don't have standing to assert any potential right of the temporary custodians to counsel at a 72-hour hearing. And they certainly do not have a right to have a third party's attorney assist them in litigating the termination of parental rights proceedings. Mother and father do not contest that they were unfit at the time of trial, and they present no evidence indicating any possibility.
So had the judge decided to appoint them counsel, would that have been permissible, the aunt and the cousin?
The judge would have had the equitable authority to do so. And actually in Jacob on 270, the court sort of went into and acknowledged that there are circumstances where this court and the SJC comment uncritically on decisions of the court to provide rights beyond those which are guaranteed to participants. But that does not mean that those rights are guaranteed. Manuel acknowledged that the judge had provided counsel and provided the custodians with a temporary custody hearing. But
at this point, when the child was removed from the aunt and the cousin, did the child have their own attorney?
Yes.
Okay. Could the great aunt have showed up with an attorney of her own?
Yes, I can't think of a reason why she wouldn't have been.
And would have had a right to be heard?
She could have requested it. I don't know that if the court had determined that that was improper, that would have been error. But that would have been a different circumstance. In this case, the great aunt did not request an attorney, did not seek to have an attorney, and again, since we're talking about the termination here, was not a party to those proceedings. The great aunt didn't seek to intervene, and the cousin, I'm speaking of them jointly, did not seek to intervene, did not seek to file a guardianship, which was a way they would have had standing to participate in the termination proceedings. And so when evaluating whether or not there was error in the termination of mother and father's parental rights, there simply was none.
Do we have a concern that there doesn't seem to have been a 72-hour hearing, and by that I mean that literally, after the removal of the child from the aunt and the cousin?
Well, we're in a weird, I guess the first response is that there was a 72-hour hearing. Father requested and received
Just 2 months later?
That is not ideal, but that is also a reflection in the docketing timelines that are happening across the Commonwealth. It is certainly to be avoided as much as possible, but we're also in a weird procedural posture here because this removal happened in the middle of a termination of parental rights. It would have been reasonable to consider, well, that's your custody determination right there. They're in the middle of a trial on the matter, pausing the trial to find the next available several open days in the court's docket to have an intervening temporary custody hearing when there's going to be a permanency plan fight at the trial on the exact same issue, but permanently, would have certainly been a struggle for the juvenile court to manage.
So go ahead. The father raises a concern that the social worker testimony was not supported by contemporary notes on two issues, at least, whether the child's play was below age level and whether the TV was on during visits. But the judge did not acknowledge that inconsistency. So what do you say to that?
The judge isn't required to make findings as to every fact that's presented, and where there are findings that appear to reject facts, testimony that was to the contrary, that is an implicit decision regarding that issue. Also, the concerns that the department had occurred later than the time that those statements were made.
So is he wrong when he says, well, all that came afterwards as a bootstrapping justification, the concerns about the aunt's care?
Yes, I apologize, I did not brief this. I'm working off of less memory than I normally have. But there were concerns that came to light, and they came to light more seriously once the child was out of the aunt's care. Once he was in daycare and they were seeing the progress he was making there, that's when he got the evaluation. And so there may have been concerns that the social worker might not have deemed important enough, given the information they had at the time, to note. Anybody who has raised a child has had a TV on. But once professionals were noting that the child was not where he should be, and they were seeing the progress that was being made under different environments, that's reasonable for the court to conclude the way it did. Also, I would disagree with my brother that what the aunt did in causing this child to be seriously injured by leaving them in an unsupervised overnight visit with the parents after being told by the court not to do that. The department certainly didn't tell her to leave the child unsupervised overnights in a hotel room with mother and father. And by Father F telling her, don't do that, that's not safe, the child is hurt. That is enough there. That would not have been error if that was the only reason.
One of the parents argues, well, the aunt made a very bad mistake that ended in a bad situation. But that there was no indication she would make that mistake again, especially if she'd been correctly educated by the department or the judge. So what do you say to that?
That's not in keeping with the court's conclusions as to the aunt. There was evidence that the aunt was arranging clandestine visits, surprise visits for the older children in the community where mom would show up and the kids were upset and that she was doing that. The court found the aunt not to be credible in her testimony, found the cousin not to be credible in his testimony, that they had arranged for overnight visits with mother in the past. And mother there are multiple findings about the fact that yes, Your Honor, sorry.
As far as how we're going to read Section 29 and who has a right to counsel, what do you say the word custodian should mean? Permanent custody, temporary custody, conditional custody, direct custody?
Reading the statute as a whole, it's referring to the initial, the custodian in place at the onset. So in this case, permanent custodian. Because if you look later in 29, it instructs the court to alert people of the folks who have a right to counsel, alert them of the right to counsel within 14 days. And as we know from Manuel and the rest of the case law, temporary custodians can happen at any time. So a temporary custodian could happen, had this 72 happened differently, it could happen in the middle of trial. It could happen 6 months into trial, it could happen well after 14 days. So the statute is only providing notice of that right to counsel within 14 days after filing. It is clearly contemplating a custodian at the onset. It is a disjunctive whatever relationship the caretaker of the child has at the time, be they bio parent, adoptive parent, guardian, some other form of legal custodian. At the onset of the proceedings, those are the people entitled to counsel, not temporary custodians who exist as a legal structure during the proceedings. I see my time is up, so if there are any further questions, I'm happy to answer, or I will just.
Is the mother correct about the timing on the Rule 60B motion, that it was within like 2 months of the disruption?
I believe it was reasonably close, but the operative issue with the 60B is that a disruption is not the sort of significant change necessary to merit it. This is not a case where the termination hinged on the appropriateness of this placement. And also the court did consider what would happen if it didn't work out in the initial plan debate. This wasn't sister in Texas or nothing. It was, we're looking at the sister in Texas, we're looking at this other sport, and if neither of those work out, we're going to recruitment. So this was not extraordinary circumstances or a substantial change that would merit a 60B, even if it had been made in a reasonable time frame. Thank you.
We'll hear for counsel from the child.
Good morning, Your Honors. Richard Shokire for the appellee child. May it please the court. My client asked this court to affirm the orders and decrees of the lower court terminating the parent's rights and freeing him for adoption. The record is replete with evidence of the parent's unfitness, which they don't.
Could you just pull the microphone a little closer?
Sure.
Thanks.
Sure. The parents don't challenge their unfitness on appeal, and the record's replete with evidence of their unfitness. The parents raised essentially 4 arguments on appeal: one of the competing plans, one of the temporary custodian's right to counsel, one of a motion for the new trial, and one for sibling visitations. If I could address these in order. With the placement, the judge adequately considered both of the competing plans. The parent's plan was simply not in the child's best interest to place the child back with his former custodian. The judge made numerous findings of fact that delegated her reasons for that. First and foremost was the child's safety. The former custodians were susceptible to manipulation. The great aunt, I believe, many times told the court investigator, the guardian ad litem and the ongoing worker, that she would lie on the stand if called to testify. Her credibility was at issue throughout the entire proceedings. And as we learned later on, the judge found that, perhaps multiple clandestine visits took place. Beyond this, if I can also address my brother's argument about evidence that was left out. First of all, the judge doesn't have to consider every potential piece of evidence that's favorable to father, but if one looks at the evidence, what he cites to are 2 statements from the social worker to the grandmother that she was doing a great job. These happened in, I believe, June of 2022. The department was unaware of clandestine visits, and they were unaware of the child's special needs. These only came to the forefront, I believe, in December of 2020 or 2021, I can't remember. And the department immediately made referrals for him to have a pediatric developmentalist do an evaluation of him for autism. This happened, I believe, a week before the removal. And it was only after the removal that the department became aware from the early intervention specialist that they had concerns all along. If I can address the caretaker's right to counsel, these were temporary guardians or temporary custodians. They did not have permanent custody under 119 Section 26. They were simply given a series of 90-day minimuses that could expire at any time and did not have to be removed. I believe my sister misreads manual in that particular case, the SJC noted that the custodians were provided counsel, but there's nothing that mandates a right to counsel for them. They were never, as the department argued, they were never parties to the case. They don't really have standing. And I presented 3 hypotheticals in my brief.
When they when they basically were the people who essentially had this child for the first 2.5 or so years of his life, do they really not have standing?
No, Your Honor. And allow me to if I could go through my 3 hypotheticals. Let's say at any time during the proceedings, the department decided to dismiss the case. Would they have standing to appeal the return of the child to mother and father? They wouldn't. Or if mother and father had won the trial, they wouldn't have a right to appeal. And more importantly, let's say that they were provided counsel and they did participate in their own 72. As a side note, there was a temporary custody hearing for the parents that they both waived. Father, I believe, only reserved the right to nominate them as third-party custodians. But even if they had counsel, even if they did get custody, once the parents were found unfit under adoption of Jacob, the judge still had full discretion to remove them and place the child wherever the best interest was for him.
Do you agree that if one of them had an attorney, that attorney would have had a right to have been heard?
They would have had to file a motion to intervene, Your Honor. They're simply not parties to the case. The attorney would have probably been left to sit out in the hall. That's been my experience. If I may move to Mother's 60B motions. Mother argues that because there was a disruption alone, this necessitates a new trial. But she fails to show that any clear error under what is required under 60B, clear error that falls outside reasonable alternatives. That didn't happen here. In my brief, I do use adoption of Caesar, which this court showed that in order for something like this to happen, there has to be some real change. In that case, mother had gotten custody of her 2 older children. The child was now 12 years old and didn't want to be adopted. The child wanted to reopen the evidence. So none of that is present here. There is absolutely no evidence. Moreover, mother doesn't have standing, and this was never raised at any point, so she's actually waived this issue. Finally, with respect to sibling visitation, mother lacks standing again to advocate on behalf of her children, and again waived this argument. There was never any evidence that was presented as to whether or not this was necessary. And there's also a misinterpretation.
What about the child? Is the child comfortable with no ordered visitation? I mean, the child was very close to at least child C and child J.
Yes, Your Honor. Under adoption of Garrett, it delineates that after post-TPR sibling visits are grounded in Chapter 119, Section 26B, subsection B, which if they're managed by either the court or DCF, here that's managed by the father of the 2 older children who mom did not want this child placed with for fear of father, and the department. Therefore, the judge has no obligation to order anything.
What do we do with the fact that there's some statements in the record, in the last hearing, by counsel that the reason for the disruption of the Texas placement was because that sister was, there were problems with mother disrupting, the placement disrupted because of safety concerns caused by mother, and that the problem with sibling visitation was that it was difficult to find a way to keep this child safe during those visitations, that he'd had virtual visitations. So we don't have a recent record that's an evidentiary hearing about
Yes, Your Honor.
Why there wasn't a more explicit order for sibling visitation and why the Texas placement was disrupted.
Again, I think that speaks to mother's unfitness. Mother and father have basically functioned as agents of chaos in the lives of all of the characters that were involved in this case. However, the father of the 2 older children and the department have I don't want to go outside the record, but visits were facilitated. May I rest on my brief unless you have anything further? Thank you.
Thank you very much. So that case is submitted, but we do have a related case, 2023-P-1095, Department of Children and Families and others versus Mother and others. And here we are going to have, we'll hear first for counsel apparently has been appointed somehow for the aunt and the cousin.
Thank you. Excuse me. Thank you, Your Honors. May it please the Court, I am Attorney Diana Spanos, and yes, I was appointed subsequently to represent the former custodians. Your Honor, I'm here today basically appealing the denial of the custodians' request for an enlargement of time to file their notice of appeal. And as such, it was denied. The single justice felt that I had not, or that the notice itself had not established excusable neglect or at least one meritorious issue. In this case, the two factors, the excusable neglect and the meritorious issue, are really very much combined, and it's the lack of counsel. There was a lot of reliance on care and protection of Emmanuel, and I can just state from my perspective, having just heard these arguments, I was a very new attorney back in 1998 when care and protection of Emmanuel was decided in Essex County, which was my court. I was actually there the day that the great aunt came in that case, and I can tell you that there was very real and significant argument around that issue. The trial judge felt, in that case, felt very, against the department's objection, felt very certain that the custodian should have been appointed counsel, and he did appoint counsel for them based on Section 24 and the emergency removal. He took the perspective that when the state removed a child from a custodian, even in that emergency basis, that there should be some type of due process hearing, a 72-hour hearing.
So if the judge at trial had ruled to give custody of the kid back to the parents, would the aunt and cousin have had standing to appeal?
No, I don't think so. I think their right it's to protect their right at that 72-hour hearing. And again, he relied on, you mentioned it earlier, upon entry of the order, notice to appear before the court shall be given to either parents, both parents, a guardian with care and custody, or another custodian. And someone, I don't remember, said, well, who's a custodian? The only word that I know, a care and protection matter is the only place I know of for a legal custodian. And as Your Honor suggested, I mean, this can go on for years. You can be a temporary custodian for the majority of a young child's life.
Right, and it looks like the case law doesn't object to a judge appointing the custodian attorney, but the question is, does it require it?
And I know that there's been a lot of discussion about the Jacob case, and in Jacob they cite guardianship of KN. And since the guardianship of KN was issued in 2017, the statute, Mass General Law, Chapter 190B, Section 5-212, Section D, was amended in 2021. And in that case, it recognizes the interests implicated in the removal proceeding where the child has lived with the custodian for a significant period of time during or prior to a guardianship. So it's up to the judge to look at that case, and the statute actually reads, for proceedings pursuant to a petition to remove a guardian of a minor child, the guardian shall have the right to counsel.
Did anybody move to appoint the aunt or the cousin as a guardian?
No. No one did. They were just the custodians. And getting back to it, it's true, when the care and protection ends, but we're talking about family here too, the kinship placement. So, I mean, I don't foresee a situation where these custodians would have objected. They don't have standing to object if the court decided to return to the parents. That's it, it's over. But in the meantime, if you respect the fact that these cases surround the best interests of the child, there should be some real due process hearing. If the state—
Would they have standing, let's say they had counsel and the judge did what she did and gave permanent custody to DCF, would they have standing to appeal? The custodians?
I'm not sure I understand. So if the judge gave permanent custody to DCF—
Right, I'm trying to figure out your reading—
While the custodians had custody?
What's the scope of the right that the custodians have
They have
to counsel? Do they have the right to cross-examine all the witnesses? Do they have the right to propose their own permanency plan? Do they have the right to appeal from any adverse determination?
Not as it relates to the parents, if that makes sense. I mean, but they're the custodians. Let me just say, again, in Essex County, and I did 20 years of trial practice in Essex County, this is how we do it all the time. If there is a removal from a custodian, that custodian in Essex County is appointed counsel.
You mentioned due process earlier. The children have attorneys, correct?
Yes.
So isn't it the children's interest that if, and again, this would have to be an older child, I guess, 12 years old, whatever, says to his or her lawyer, I want to stay with temporary guardian. So the child's interests in that sense are protected.
Are protected. But I appreciate Justice Henry's comment. If someone has been caring for a child for 2, 3, 4, I mean, this can go on for a long time. This court is aware of how long these cases go sometimes. That guardian don't they have standing? Yes, they do. Yes, they do. But it is limited in scope. It does not extend to if the judge eventually determines that the parents are fit and the child should go home, they go home.
But see, there's the issue is, they have standing to do what? Let's say temporary guardian is not a family member. It is somebody that DCF has chosen. And they say, I don't think mom or dad is appropriate. I want to come in and fight it. Do they have a right? You just said they don't have a right to do that. Why not? They either have standing or they don't.
I would say that I can't think of a situation where DCF would be finding a custodian to place the child with. Just like in this case, when their own regulations wouldn't allow them to maintain the placement as a foster home, they had to give up, they couldn't keep the child there.
So
they
if the child
suggested
was,
to the
if it
judge.
was still a foster home, there would be no standing. Is that what you're saying?
If it was a foster home, there would be no standing. And I will say, I think the department mentions in their brief about them being conditional custody. And I would say that it is very typical for the judge when they grant custodians custody. DCF is hands-off. They don't have custody of that child. They won't drive that child anywhere. It is solely the custodians. They won't provide visitation. It's up to the custodian. So that's why the judge will frequently write in conditions of custody, and they surround visitation.
But we don't have that order in the record.
No, we don't. And what was interesting in the discussion in the record was that the custodians apparently never got a copy of the MIT, it's called. I don't even know why it's called a MIT. And they only speak Spanish. They're, everything. So I don't know that they really recognized, what the extremes of the conditions were.
Counsel for the child suggested that if this had occurred, that the temporary custodian would have basically been left outside if they had a lawyer and wouldn't be allowed in. Is that your experience?
I respectfully disagree.
So that's your experience
in my experience in Essex County, you would be appointed a lawyer, if qualified, if they were determined to be indigent. If they had money, they could bring their lawyers in. Their lawyer would participate at the 72-hour hearing.
and doesn't file a motion to intervene or anything, is just allowed to participate.
No.
Is there a limit to how many temporary guardians there could be who could be entitled to counsel? I could imagine a scenario where several different relatives are temporary guardians and the kid is moved around for some reason. Do they all have the right to counsel?
I would certainly hope that that is not true. But no, in my experience, I've never seen that happen.
But isn't the way to get those higher rights to have somebody seek to appoint the person a guardian?
I'm not sure I understood the question.
In other words, the aunt and the cousin are conditional temporary custodians, but they're not guardians.
They're not guardians.
And the parents have not asked to appoint them as guardians.
Correct. Correct.
And as I understand it, if they were guardians, then they would have more right to be heard than if they were merely custodians.
You know, I'm not sure about that. And in my experience, again, when I did file a guardianship petition, and there were a couple of times where I asked to have the matters consolidated, and I was denied. So in that case, we weren't allowed. We had our own separate hearings, and they were separate and apart. Now, when it came down to a final trial, they would obviously have to be together.
So when we look at the language of Chapter 119, Section 29, there's no distinction of custodians. There's no distinction between permanent or temporary.
No.
But it does say the parent, guardian, or custodian of the child. So what do we do with the or? You're saying we should read that as and?
I look at it as Section 24 being every time there is an emergency removal, it starts the clock again.
Do you have the language you're looking at in Section 20? I brought the
I do have it somewhere here.
I still use the books.
Yes. Whenever the department or a licensed child placement agency is a party to a child custody proceeding, the parent, guardian, or custodian of the child, or a parent or guardian of an adult. No, I do understand what you're saying, but I look at it just as the judge did in Care and Protection of Emmanuel. When there was a subsequent emergency removal by the state, that is the very definition of state intervention.
Right, but Section 24 is over a page long, so I'm trying to figure out which paragraph you're in, what language.
Oh, I'm sorry, I was reading Section 29.
Okay. But I thought you said Section 24 is the 72-hour provision.
Section 24 discusses when there is an emergency removal.
Right.
And then notice should be given to the parent or guardian, or if they can't locate the parent, whoever the custodian or caretaker of the child. And again, the difference between my brother's argument and mine is that I believe, as was done in Emmanuel, that any time there is an emergency removal, it triggers that need for a 72-hour hearing, and that the custodians would have had a right to participate, which was
Does it matter that the child was not removed from the custody of the aunt? The child was removed from the hotel?
No. Because they were the custodians.
So where the aunt and the parents were aligned, that they all wanted the aunt to have custody, why is that not enough protection?
Well, and that's what adoption of Zelda sort of looks at. And I would say that, excuse me, in Zelda, let me get my, they were told that in Zelda, the department argues that the custodians were able to testify here, and that was sufficient because other counsel were asking them questions. But they, again, without their own counsel, they were relying on the parents' counsel to sort of ask those questions. Parents' counsel had their own conflict. It was their clients that caused...
Or the children's counsel.
Or the children's counsel.
And again, I go back to what you said earlier, the due process rights. The children, if their attorney believes that the temporary custodians is in their best interest, the questions would be posed in that form, so it is protecting the custodians, isn't it?
No, it's not. It's not. It's because, again, and I'm going back to, and by analogy referencing the probate court statute 190B, section 5, they've been caring for this child for years, according to the stat, a minimum of 2 years. They've paid for that child. They've taken that child to the hospital.
Let's assume we agree with you that your clients have a meritorious issue for appeal. When we're looking at the single justice's order, how do we get past the fact that she found that there was no excusable neglect because your clients waited 4 months to file the notice of appeal after the mom's lawyer had tried to do so on their behalf?
And the only answer to that is the bureaucracy of trying to get through to the committee, the CPCS, to get them to, act and do the right thing. I was appointed in August 25, I think the single justices, but there was a lot of back and forth going, and you can't blame the custodians for that. That's not their fault.
I did not want to ask how you got appointed, but you've raised the issue.
Well,
in the sense of when an attorney is appointed, CPCS has to have the authority to appoint.
Mm-hmm.
What authority does CPCS have to appoint for a temporary custodian?
I think you've got to ask them. I don't know. I can't reflect on that. I just know that this is how this is how law evolves. How about that? And if your honors have no further questions of me, I will rely on my brief.
Okay. I think now we will hear from the department and counsel for the child, and there's a time split here with 10 minutes to the department.
May it please the court, Jeremy Bayless again for the Department of Children and Families. As a practical matter, the issue here is rendered moot by the termination of the parent's parental rights. Even assuming everything worked out the way that the temporary custodians wanted to. It goes back for a temporary custody hearing. They win. They get temporary custody of the child back. There is no custody to happen there. The parents' parental rights have been terminated. They did not have standing as parties to participate in that decision. There is no relief that can be offered to them at this stage. But that need not be reached because their position is also not merited.
Couldn't there have been relief offered to them shortly after the child was removed?
That would have required them to be, had there been space in the court's docket to be able to have a 72 before that was able to conclude before the conclusion of trial, they could have been a lot of assumptions, but assuming everything the same as I just said, they could have been given temporary custody for however long it took the trial to close. But then the same evidence would have been introduced, the same lawyers would have conducted the trial, and the same outcome would have been reached, which is that the parents are unfit and termination of the parental rights is in their best interest. The guardians would, or the temporary custodians would not have been able to participate in the plan fight beyond being called as witnesses because they did not seek to intervene. They didn't file a guardianship. They did nothing that would give them legal standing there.
Custodians' counsel says that's not accurate. She says that in Essex County, where she practiced, they do participate. What do we do with that if it's happening in one county, but apparently maybe sometimes not happening in others?
Well, so I guess there's two things. First is I can't really testify to you today about my practice. That's not where I got to hear from. Secondly, I don't think it's disputed the idea that this can happen. Judges can appoint counsel.
That's the part that I don't know. And I know there's a few cases that talk about the discretion. It seems to me a court needs to say temporary custodians either have standing to argue and do something or they don't.
Well, I think the difference is, I mean, to the extent that my sister is related to practice there, I don't know that that is in keeping with the intention of the statute. That might be a systemic implementation of the judges deciding that we should use our equitable powers to make this happen. And they have the ability to do that. It gets a little weird when it's at that level, but okay.
Should we make a decision whether they have standing or not? And if so, what is your position?
They do not. They have the ability to be allowed to participate by the court at the court's discretion, but they do not themselves have standing as a party. And as Your Honor noted, there's not really a sort of half standing where you can, you have rights to challenge, because as has been coming up, it is not always the case that a temporary custodian gets along with one or both parents. They could be a relative who's, I apologize for being colloquial, sick of both parents, but is wanting to provide a safe place for family. They could be linked with one parent but not the other in situations where the parents aren't aligned. And so what happens if there's a temporary custodian and they have standing to participate with the lawyer and litigate, and a judge determines that conditional custody should be given back to a parent for some reason? Would a temporary custodian have standing to dispute that? No, that would be an outcome that is contrary to the rest of the thrust of child welfare law, to the constitutional rights of parents.
I know, but I think there's an issue here. I'd like to think we could all agree that children are not potted plants and you cannot just move them around without repercussions.
Yes,
and
Your Honor.
if the aunt had, and by her I mean the aunt and the cousin always, but if the aunt had an attorney she could turn to, she might have been able to ask questions like, well, Mom says this is okay, is it okay? Or her testimony might have been different at the hearing because the attorney might have educated her about certain issues, including whether or not to be tricked by the parents.
Well, at the hearing, while she did not have her own attorney, it is obviously practice of attorneys to prep their witnesses, and the attorneys that were going to call and present the aunt as a potential permanency plan certainly could have prepped her. I think they probably did. And the problem is that the aunt was not a credible and reliable witness, which is what was found to be the case.
Yeah, I know, but one of the reasons she got tripped up was because she said she didn't meet with the attorney ahead of time, and anyone who's litigated for 20 or 30 years knows that there are certain cultures that just won't, they'll just lie because it's just not okay in their culture to meet with an attorney, and then a good attorney then educates them about how that's going to end their case. And so they need to get over their cultural situation and they need to tell the truth.
Certainly, but I mean, I think what it really comes down to is that the child's rights to a stable placement and to not be harmed, because those are the child's rights, those aren't the custodian's rights. Those are represented by child's counsel. And child's counsel, under Manuel, under everywhere it's ever been written, child is a party, child has a right to a temporary custody hearing, child has a right to put forward, and child is an appellee here. Child's position was not that they would be harmed if they were moved from the aunt and uncle. Child was physically harmed because of the actions of the aunt and cousin, sorry, not uncle. So while it is certainly not good
Right, so in that situation, the child and the child's counsel is not aligned and therefore can't represent the interests of whatever they may be of the aunt.
Well, we're looking at two different things. Your Honor asked me about the harm to a child of moving them. That harm, that right to be protected from that harm is the child's. That is not the aunt's interest. That's not a temporary custodian's interest. Their interest is that they want the child to stay with them. Because they're not a parent, they don't have that right to advocate on behalf of their child. So it's not 100% clear what that interest would be if they had standing, versus a court may determine that for uses equitable powers, it is of my benefit as a finder of fact to determine what is best for the child to hear from you. And the way I choose to do that is to appoint counsel. But standing on its own, it's not clear what interest the custodian would have. Best interest of the child, that's covered by the child, and the parents have the right to weigh in on that. The caretakers are simply trying to keep the child there. And that is reflected in the structure of 29, in the notice requirements in 24, where they use a disjunctive or. Someone on this list, parent, guardian, custodian, gets a lawyer because whichever one of them it is, that's who had the child at the beginning. That is the person where the child was living at the onset, at the filing of the proceedings. A removal from a temporary custodian is not new proceedings. It is not a separate action. And so the notice of counsel happens within 14 days of the filing that initiates the proceedings. Temporary custodians can happen later, as I had stated earlier, but since this is a new case, that indicates that where it talks about custodians, it's talking about custodians as a potential person who had the child at the onset, not the temporary custodians that might arise in the middle.
If the custodian had filed a motion to intervene, pro se,
yeah,
would a judge then have authority to appoint a lawyer for the temporary custodian if he or she allowed the motion to intervene? And if so, under what statute?
I believe they would, because then they would become a party. And I apologize, I do not have an
I guess
answer
the
for you
question
under
is
what
a party,
statute.
they're a party to the action by being allowed to intervene, but
I actually think it might be a situation where the judge, again, has the equitable authority to do so, but is not obligated to. Now, that changes the calculus of when to exercise the equitable authority greatly. Okay. But that then would give them significantly more legal standing. Similarly, they would have had a lot more rights to participate in the termination proceedings had they filed for a guardianship, which is addressed in the case law and raised in the brief. But it's also important, as my time is winding down, to go back to the fact that this isn't an appeal on the merits. This is an appeal from the denial of an extremely late notice of appeal. And while there are procedural impediments that go in there, this was an issue that was known to the aunt and uncle well before they filed the appeal. They could have done so pro se, not that that's always the best course of action, but they had the right to do so. And the single justice did not err. That I will yield to my brother.
We'll hear from Attorney Shoker.
Good morning, Your Honors. Richard Shokar for the child. May it please the court. Your Honor, I joined the department's brief on behalf of the child. I believe all the issues were resolved in their brief. I'm here simply to answer any extra questions that you may have. But other than that, I simply rest on that brief. To me, this is simply a single issue of did the single justice err in disallowing a very late notice of appeal of two people who were not parties to a case. And if I could provide just a quick analogy, there is an unpublished case, I believe it's called Adoption of Berry, that may provide some guidance by analogy. In that case, there was a putative father who was provided counsel by the trial judge and was included in the proceedings, and the judge terminated his parental rights. He appealed that, and this court found that the court didn't have jurisdiction to order anything. He wasn't a party to the case, and I think that's similar here.
Do you agree that the judge had the discretion to appoint counsel, just not the obligation?
Of course, these are discretionary things. The judges have broad discretion. These cases aren't, here's the elements, did they happen or not, beyond a reasonable doubt. The judge has a lot of discretion. But again, I don't believe that in this particular matter, the court even really had the jurisdiction to do something like that, especially since they were just temporary custodians. I have nothing further unless you have any questions.
All right.
Thank you, Your Honor.
Thank you. The case is under submission, well argued, and with that, that concludes our sitting. I want to thank our court staff for all the work they do to make these sittings happen, and we will be in